Good morning, everybody. It is me, 7th Hanuman. Today, I want to share the current targeted justice lawsuit against the quote-unquote people behind gang stalking. And if you've been following my channel, you know how I feel about lawsuits as a TI. And if you're a TI and you want to have a lawsuit, then go ahead. I'm not trying to discourage anybody. If you feel like you need to file a lawsuit, then maybe you should get that out of your bucket list. Because if you've been thinking about it, and if you don't do it, then it's just something that will be bothering you through lower voice to skull. Like I was been telling other TIs, if you have a fear, if you have any thought that it's related to gang stalking, then you need to go confirm if those thoughts are true or false. Because if you don't do that, the lower voice to skull will kick in and will bother you, and it will frustrate you, and it will not make you happy unless you find out if it's true or not when you receive those thoughts. For instance, your neighbors are coming over. So you must do everything you can possible to know if it's your neighbors or if somebody else or whatever's happening. If you don't find out, the lower voice to skull will bother you on a regular basis, remind you that, oh, it's your neighbor. But if you don't confirm if it is your neighbor, then you're just really beating yourself in this gang stalking phenomenon. So today I will show you guys the current lawsuit, and you guys can listen to it. I will use the computer to play it, read it out loud, and you can just listen to it, and you can decide if the lawsuit is any good or not. And I will stop, during the audio and analyze what I think of it. So let's get started. So here's the website, Targeted Justice. On the top says lawsuit. I click on that. And so I guess they filed a lawsuit on 11th January 2023. So let's listen to it. So this is a long text. It's a lot of pages, but let's just listen to it. So
0 to 5,991 text of the lawsuit filed on January 11, 2023, amended. In the United States District Court for the Southern District of Texas Victoria Division, Targeted Justice Incorporated, a 501c3 Texas corporation, Dr. Leonid Biar, Dr. Timothy Shelley, Karen Stewart, Winter Calvert, Armando de la Torre, Jasmine de la Torre, J.D., a minor, Deborah Mahanger, L.M. a minor, Lindsay J. Penn, Melody A.N.N. Hobson, A.N.A. Robertson Miller, Yvonne Mendez, Devin Delaney Fraley, Susan Olson, Jean Kong, and Jason Faust, plaintiffs, versus Merrick Garland, in his official capacity as Attorney General of the United States, Department of Justice, 950 Pennsylvania Avenue, NW, Washington, D.C. 20530, Federal Bureau of Investigation, 935 Pennsylvania Avenue, Northwest Washington, D.C. 20535, Christopher Wray, in his official capacity as Director of Federal Bureau of Investigations and in his personal capacity.
Okay, so right here, they're actually suing these people. Merrick Garland, they're suing the FBI, Christopher Wray, Charles Cable Jr., the Department of Homeland Security. So these are the people that this this private lawsuit, they're suing these people. And the plaintiffs, or TIs, are these people right here. These are the TIs. From this list on, from up here down to here. And these are the defendants starting from here. So let's continue. I mean, right off the bat, you're going to need some really strong evidence to sue these people. And I'm curious to know what type of evidence that the plaintiff have.
NW Washington, D.C. 20535, Christopher Wray, in his official capacity as Director of Federal Bureau of Investigations and in his personal capacity, Charles Cable, Jr., in his official capacity as Director of the Federal Bureau of Investigations Terrorist Screening Center and in his personal capacity, Department of Homeland Security, 245 Murray Lane, SW Washington, D.C. 205280075, Alejandro Mayorkas, in his official capacity as Secretary of the Department of Homeland Security and in his personal capacity, and Kenneth L. Wanstin, in his official capacity as Department of Homeland Security's Under Secretary for Intelligence and Analysis and in his personal capacity. Defendants. Amended writ of mandamus, complaint for declaratory and injunctive relief and damages to the Honorable Court. Now come the plaintiffs: Targeted Justice Incorporated, Leonid B.R., Timothy Shelley, Karen Stewart, Winter Calvert, Armando De La Torre, Berta Jasmine De La Torre, for themselves and on behalf of their minor daughter J.D., Deborah Mahanger, on her own behalf and on behalf of her minor daughter L.E.M., Lindsay J. Appen, Anna Robertson Miller, Melody A. Hobson, Devin Delaney Fraley, Yvonne Mendez, Susan Olson, Jean Kahn, and Jason Faust through their undersigned counsel, and respectfully allege and pray. Introduction. Under the guise of national security, for decades the agencies of the United States government have subjected unsuspecting American citizens to cruel, illegal, covert human experimentation. Executive Order 13526 provides that in no case shall information declassified, continue to be maintained as classified, or fail to be declassified in order to conceal violations of law, inefficiency, or administrative error. From 1953 to 1966, the Central Intelligence Administration, CIA, sponsored the MKUltra program to control human behavior. CIA v. Sims, 471 U.S. 159, 1985. The program's stated purpose was that of developing brainwashing and interrogation techniques. Orlico v. United States, 682 F. Suppa 77, DDC 1988. Unsuspecting subjects underwent long-lasting, cruel experimentation without their knowledge or consent. During 1975 to 76, Congress carried out an investigation of the MKUltra program. The Church Committee, under the direction of the late Senator Frank Church, held hearings that resulted in the apparent shutdown of the program. Upon concluding his investigation, Senator Church tried to rein in the corrupted intelligence agencies when he publicly warned everyone that the National Security Agency's capability at any time could be turned around on the American people, and no American would have any privacy left, such as the capability to monitor everything, telephone conversations, telegrams, it doesn't matter. There would be no place to hide. If a dictator ever took over, the NSA could enable it to impose total tyranny, and there would be no way to fight back. Likewise, the COINTELPRO program that started in the 30s was designed to crush political opposition through the use of illegal surveillance and persecution tactics. In Puerto Rico, its effects were particularly devastating as the program known as Las Carpetas was used to imprison people, ruin their careers, fire them from their jobs, terminate their education, and permanently discredit them. It was used to control the politics and society of Puerto Rico through fear, intimidation, and outright blackmail. 1.
All right, I have to stop here because I think this part right here is starting to go off topic. And, well, I mean, there's a lot more to it, so I guess we can continue listening. But the more that's on, more complaints or more that's being put into this lawsuit, it's just more way for the defendant to request evidence of these claims. And they better be bringing strong evidence. Otherwise, I don't see how they can convince the judge that the defendants are guilty, especially when talking about the FBI. You will need official FBI documentations proving that this program is happening. And during the discovery phase of the lawsuit, when requesting evidence from the FBI will not provide those evidence because the things they do are secret. So that is where the whistleblower will come in play with a USB hard drive, just like Edward Snowden, with all these official documents, official information on there. Like they will need that. A whistleblower from the FBI with a little USB hard drive that has official documentations. Otherwise, the FBI will not willingly just hand over these documentations. So during the discovery phase of the lawsuit, I don't know how they're going to be able to obtain these type of documentations, but maybe they'll mention that later on. So let's continue.
1. In the year 2000, speaking about the COINTELPRO and Las Carpetas, defendant FBI Director Louis J. Free admitted in a House Appropriations Subcommittee hearing that the FBI did operate a program that did tremendous destruction to many people, to the country, and certainly to the FBI. Free then vowed to redress some of the egregious illegal action, maybe criminal action, that occurred in the past. Presently, defendants jointly collaborate with another illegal covert human experimentation and persecution program, a hybrid behemoth that combines MK Ultra and COINTELPRO's Las Carpetas. Labeled with the nondescript moniker of the program, its global scope aims to control and destroy opposition. Hundreds of thousands of American citizens and lawful U.S. residents such as plaintiffs are subjects of this program funded with billions of American taxpayer money. On April 26, 2011, 40 Mayor FBI Senior Special Agent in Charge Ted Gunderson stated in an affidavit under penalty of perjury that thousands of innocent victims have been targeted by an illegal government ongoing, active, nationwide rogue criminal enterprise that is active 24 hours a day within the U.S. whose increase in scope, intensity and sophistication was made possible by the new communications and surveillance technologies. See Exhibit 1. Plaintiffs request that this court take judicial notice of this statement, filed within the case Labella v. Federal Bureau of Investigation, 11 CV 0023, NGG, LB, EDNY March 16, 2012.
All right, let's check out what's Exhibit 1. Exhibit 1, well, I guess this word only shows up one time. All right. Let's go to Exhibit. Exhibit 2, Exhibit 3. Okay. Well, I guess they don't have Exhibit in here. Well, maybe that's private. So let's just continue.
2012, 1C The War Against Puertoricans, https://warajinstallpuertoricans.com/carpetas. Individuals in this nefarious program are referred to as targets. They are subjected to illegal and unconstitutional phone taps, illegal rerouting of business and private phone calls for harassment purposes, surreptitious entry into home, office, and vehicle, virtual surveillance in the home conducted by illegal placement of miniature remote, wireless cameras, often accessible through the internet, illegal internet spyware, illegal GPS tracking, often through their own mobile phones, regular fixed and mobile surveillance, mail misdirection, mail theft, and tampering, financial and employment sabotage, slander campaigns, poisoning, assaults and murder, illegal setups on drug charges and other felony charges, amongst many other civil rights abuses.
Now, they mention a lot of stuff here. This is a lot of information that requires evidence to prove these claims. And how are they going to prove just this one alone, the surveillance or mail misdirection? I mean, I don't know how they can prove this. How can they prove that the USPS is misdirecting their mail because, or they're under the order of some government agency? How are they going to prove this? Mail theft, okay, I guess they can, if they caught the thief, but that is just mail theft. How is that going to be related to FBI or anything else? Employment sabotage, how is that going to be related to FBI and other things? I mean, do they have someone that willingly come forward and said, oh, they're hired by the FBI and here's the pay stub, here's the documentations, all the stuff I got from them, and I was hired to sabotage this person's employment? Like, how are they going to prove all this? Poisoning, how are they going to prove poisoning?
Abuses. ID. Technological advances have been incorporated into the illegal organized stalking and surveillance, including the use of microwave weapons for inflicting physical and psychological torture that ends up causing them the condition known as Havana syndrome, remote neural monitoring, and voice-to-skull auditory symptoms. For decades, an impenetrable wall of plausible deniability camouflaged perpetrators' crimes against targets. The program's sophistication prevented victims from identifying with clarity the abuses and tortures perpetrated against them, and also from articulating the mechanisms by which these abuses and tortures were being deployed and executed. Any target who identified or attempted to report the abuses and torture was accused of being mentally ill. Rather than commencing investigations into these serious crimes and prosecuting the perpetrators for their criminal conduct, federal, state, and tribal law enforcement agencies colluded to institutionalize its victims and declare them mentally ill or incompetent.
Now, I gotta stop here. You've been following my channel, you know, I always tell you guys, TIs are not mentally ill. TIs are just in the dark when it comes to whom are these gang stalkers? Because as soon as the TI know whom these gang stalkers really are, everything will make sense. Everything will make sense. Just like patients that hears voices, okay, schizophrenia, okay? They don't know where these voices are coming from. And the medical industry do not know these voices are real. But once the patient knows, then they won't act crazy anymore. They won't behave a certain way that can be labeled as crazy. They just don't know. And when they try explaining it, the doctors think they're crazy, or the doctor's not experiencing it. The doctor have no direct experience. They have no idea what's going on. And it's a trend, it's a norm for them to label these people as showing signs of symptoms of having delusions. When they are not, they're telling the truth. They're experiencing it, but they just don't know. They can't put a label on whom is creating these voices. Just like gang stalking, with TIs receiving V2K. But like I said before, all TIs receive V2K. The ones that don't believe they're receiving V2K, you're listening to LV2K, the lower voice to skull. And the lower voice to skull is telling the TI these different things that the TI believe is his or her own thoughts. So once the TI know whom these gang stalkers are and whom is doing, okay, the V2K, then everything will make sense. And I will show you guys this coming April. Less than 2 months, I will show you guys. No, exactly about 2 months from now, I will show you guys.
Incompetent. Plaintiffs and 450 TJ members' substantially similar accounts counteract the program's cornerstone plausible deniability that allowed its unchecked operation for decades. The targeted individual program obtains its experimental subject roster from unconstitutional subcategories of the Terrorist Screening Database, TSDB, that contains the names of people who have no ties to terrorism. In the exercise of their discretion, defendants Ray and Cable Jr. decide the fate of unsuspecting individuals such as plaintiffs, condemning them to a life of premeditated torture.
Okay, this is very important. So right here, here's the actual, this statement right here is very important right here. So this statement, they're actually are talking about this list, okay, this database, terrorist screening database, okay, and contains the names of people who have no ties to terrorism. Now, okay, I get it. I see the possibility of this list being out there. But how are they going to get this list? They're not going to hand over this list. So how are they going to get this list and show it to the judge? And even after showing to the judge, let's say they do get the list, and let's just say the TI's name are on there. The defendant will make up a reason. Okay, the defendant will just make up a reason. Let's just say if they even reach that far, they'll make up a reason as to why the TI is on the list. And then what? I mean, that's their job, right? So it's like, this alone will be a very tough thing to do. That's if they hand over the list. If. And I don't see why defendant getting sued would want to hand over information like this, just to help out the plaintiff. It doesn't make any sense. I mean, no one would do that using common sense. But I might be wrong. And you have to prove premeditated torture, premeditated. So that alone needs to be proved. It's just so much needs to be done here. And I feel like just that alone could just keep dragging this thing on. And you have to understand, okay, that the TI in this lawsuit, let's just say the lawyer's doing it for free, pro bono, doing it for free, okay? Like the lawyer will only get paid if they win. If the judge will give out, damages paid to the plaintiff. If the TIs don't win this lawsuit, then the TIs will have to pay for the defendants' lawyers. And that's going to be a huge amount of money paying out to the defendants' lawyers. But those are the options. Those are the possibilities. Let's continue.
Former Terrorist Screening Center, TSC, Deputy Director Timothy Grow admitted that the TSDB contains names of people who have no ties to terrorism. In a statement given under penalty of perjury, Mr. Grow expressed that the TSDB contains information of individuals who constitute an exception to the reasonable suspicion standard, who are not considered known or suspected terrorists, and are not screened as such.
Okay, so I want to see this Exhibit 2. So this person Timothy admitted that the TSDB contains names of people who have terrorism in a statement given under penalty. Okay, so this person admitted there's a list, and I hope this Exhibit 2 shows the list. But there is no exhibit in this text format, so I wonder what this Exhibit 2 is. I really want to see this. But so far, the exhibits are classified. Let's continue.
Such. See Exhibit 2, emphasis ours, point 2. Grow's specific words were the following: JPG pursuant to federal art.avid. 201 C2 and D. Plaintiffs request that this court take judicial notice of the adjudicative facts contained in Exhibit 2, including the statements set forth above. The TSDB's subcategory of individuals who are not known or suspected to. Please see Timothy P. Gross statement under penalty of perjury dated March 19, 2019, submitted in case El Hadi v. Cable 391F. Subpoint 3D 562 E.D.VA 2019.
See, I want to look more into this lawsuit right here because they're referencing from another lawsuit. This one, El Hadi versus Cable. So it's important to look into these reference lawsuits because they're trying to support their claim by using previous lawsuits. So it's important to look them up, and I would do that later on.
2019, terrorists is also known as non-investigative subjects, NIS, and are listed under handling codes 3 and 4. The consortium of governmental agencies acting under the guise of national security have secretly, unconstitutionally, and maliciously sentenced each NIS to undergo a lifetime of covert human experimentation that targets and tortures these human beings, in many instances to their death. Without sufficient grounds to link an individual to terrorism, an unwitting person's placement on the TSDB's NIS/handling codes 3/4 lists is the equivalent of being indicted, tried and sentenced to a lifetime of torture and physical and psychological abuse in violation of this country's constitutional prohibition against cruel and unusual punishment. Defendants' unrestricted inclusion of NIS in the TSDB has resulted in huge swaths of the population that have nothing to do with terrorist activity included in an atrocious experiment without their consent and against their will. Consequently, an unprecedented number of people such as plaintiffs have emerged to publicly expose their experiences enduring these criminal attacks that go unstopped and unpunished. The cloak of invisibility that, for decades, shielded the program from exposure no longer exists. Stated another way, the TSC includes American citizens and legal residents that are not known or suspected terrorists in its terrorist database under the purview of defendants Ray and Cable Jr. for no purpose other than secretly enlisting them in an involuntary human experimentation program that targets unsuspecting victims, divesting them of their autonomy and destroying their lives, with no recourse. Plaintiffs and TJ members are victims and survivors of these crimes against humanity and the deprivation of their fundamental constitutional, civil, and human rights. Plaintiffs come before this court to petition for the redress of their grievances and protection from these shocking abuses, to request that this court declare unconstitutional the NIS/handling codes 3/4 subcategories of the TSDB and or to direct that their names be removed from it, and to hold defendants jointly and severally liable for the damages they've sustained as a result of the outrageously vicious, illegal, and unconstitutional tortures and constitutional violations they have endured as targeted individuals. Jurisdiction and venue. The court has federal question jurisdiction under 28 U.S.C. Section 1331 because this action arises under the Constitution, laws, and treatises of the United States of America, 28 U.S.C. 1346, A.2, because it includes claims against agencies of the United States. Article 3, Section 2 of the United States Constitution because the rights sought to be protected herein are secured by the United States Constitution, the Mandamus Act, 28 U.S.C. Section 1361, the court's equitable jurisdiction to issue an injunction. To compel an officer or employee of the above-named federal agencies to perform his or her duty under 28 U.S.C. Section 1361, and the United Nations Convention 1753 against torture and other cruel, inhuman, or degrading treatment or punishment, ratified by the United States of America in 1994, Convention against Torture. The court has authority to grant declaratory and injunctive relief pursuant to the Declaratory Judgment Act, 28 U.S.C. Sections 2201 through 2202, Rules 57 and 65 of the Federal Rules of Civil Procedure, the Administrative Procedure Act, APA, 5 U.S.C. Section 706, the Privacy Act, 5 U.S.C. Section 552, A, 4, B, and 28 U.S.C. Section 1361. The court has authority to award costs and attorney's fees against defendants under 28 U.S.C. Section 2412 and 5 U.S.C. Section 552, A, 4, E, I, since this action is brought against officials of the United States acting in their official capacity as well as agencies of the United States.
Okay, so now they're saying the court can award costs of an attorney's fees. So if this attorney that they hired, I got her name, it's the lady. It's this lady right here. It's this lady. Anna Toledo. So she's the attorney that's representing the TIs. And I don't know if she's doing it pro bono for free and only collects when they win. And I hope that they are getting this case pro bono. But what if they don't win? Well, then the plaintiff, imagine what the defendant's lawyer will cost, because they will come back and they will actually ask the judge to pay for their attorney's fees as well. If they win, if the defendant win, their attorney is going to ask the plaintiff to pay for their attorney's fee. And you're talking about the FBI. How much does their attorney cost per hour? Or one of those former directors or directors of those agencies. And the plaintiffs are suing them at their official and private or personal capacity. So imagine the attorney's fees, $500 an hour. It's going to be somewhere around $300 to $500 an hour. So this lawsuit can be dragged on, and it's just paycheck to these attorneys. They just see dollar signs. Well, unless Anna is not getting paid up front. So, but if she's getting paid up front, then she's making money just by just reading information. And I think she made a mention that she threw it out there. She spent about 500 hours reading information in that video that I just showed you with her face. So she kind of hinted that she already read about 500 hours worth of information. So if she's getting paid by the TIs at $300 an hour, that's already $150,000. But she might be doing it pro bono because she's asking for the defendant to pay for the attorney. Usually it's probably pro bono.
States. This court also has jurisdiction to award damages pursuant to 28 U.S.C. Section 1343(a)(4) and 28 U.S.C. Section 1357 in Bivens v. 6 Unknown Named Agents of Federal Bureau of Narcotics, 403 U.S. 388, 1971, etc. And plaintiff's civil rights arising from the 1st, 4th, 5th, 6th, 8th, and 14th Amendments, as well as the Convention Against Torture. Prior to the filing of this complaint, plaintiffs served on all defendants a demand letter with the intent that it should take the immediate compulsory actions contained therein. See Exhibit 3. Prior to the filing of this complaint, the named individual plaintiffs sent Defendants Privacy Act requests under 5 U.S.C. Section 552(a), as specified in paragraph 56 below, incorporated by reference herein. Defendants' failure to provide each individual plaintiff an adequate reply under the Privacy Act compelled the filing of this complaint. Venue is proper under 28 U.S.C. Section 1391, B2, and E1b, because a substantial part of the events or omissions giving rise to the claims set forth herein occurred within the Southern District of Texas.
Okay, so right here, this is what drives them to file this complaint is defendant failure to provide each individual plaintiff an adequate reply under the Privacy Act compelled the filing of this complaint. So the reason for them to file this lawsuit is because they sent the defendant Privacy Act request under this code and paragraph 56, but then the defendant never got a response from them. So that's what led them to file this complaint. But then, okay, that's fine. So if the law says they have to respond to people requesting the Privacy Act, then yeah, they technically broke the law by not responding. But that alone doesn't lead to all the other claims. Because one thing, you requested information and they didn't send it back, okay, that's one thing. But then to say they didn't send it back, and I'm filing a complaint against you now, but yet adding all these other things, tortures and sabotage and being surveillance, like all those are bold claims that require strong evidence.
Texas. The parties plaintiffs. Targeted Justice Incorporated, TJ, is a 26 U.S.C. Section 501(c)(3) nonprofit, nonpartisan Texas corporation that represents the interests of targeted individuals, TIs. TJ's mission is to educate the public with information, news, and support for TIs to help them navigate through the trauma and destruction that this phenomenon produces in their lives. TJ's goal is that of stopping the illegal surveillance, organized stalking, and global use of directed energy weapons and torture against civilians within and outside the United States. TJ appears on its own behalf and on behalf of its over 3,500 members, TJ members. TJ maintains the website http://www.targetedjustice.com and publishes a newsletter http://www.targetedjustice.substack.com to disseminate news and information on matters of public interest and practical advice relating to the targeting of individuals. Its website averages 120,000 page views per month. It has a membership of over 3,500 individuals that have sustained and continue to suffer injury in fact as a result of defendants' illegal and unconstitutional acts and omissions in the course of their official duties. On February 12, 2019, Targeted Justice sent a cease and desist letter to defendants FBI, Cable Jr., USDOJ, and DHS demanding that they immediately cease and desist their use of government personnel and any external groups to commit organized stalking activities against targets, attacking civilians with psychological torture techniques, including stalking, gang stalking, harassment, and intimidation. For the declaratory judgment and injunctive relief portions for this complaint, TJ appears on its behalf and on behalf of 450 of its members who submitted information demonstrative of their injury in fact resulting from defendants and their predecessors' unconstitutional and illegal continuous and uninterrupted conduct dating back to at least 2003. Individual plaintiffs. Plaintiff Dr. Leonid B.R., of legal age, single, U.S. citizen, medical doctor, resides in Bloomingdale, Illinois. Plaintiff B.R. became aware he was a TI on or around 2019. Plaintiff B.R. came to the United States in 1993 on an H-1B visa and in 2003 became a naturalized citizen of the United States. Although his family migrated from Russia to Germany, he instead chose to come to America because of our nation's dedication to the Western principles, its history, the Constitution, and the Declaration of Independence. Coming from a totalitarian regime, it never occurred to Plaintiff B.R. that he would encounter governmental operatives acting in contravention of the Nuremberg Code and the Geneva Convention, violating their civil rights and their presumption of innocence. Plaintiff B.R. has been diagnosed with Havana syndrome. Plaintiff Karen Stewart, of legal age, United States citizen, married, retired National Security Agency intelligence analyst residing in Columbia, Maryland. Ms. Stewart is a whistleblower that believes she's became a TI around 2006. Plaintiff Dr. Timothy Shelley, of legal age, United States citizen, single, investigative journalist and attorney at law, is a resident of Kennett Square, Pennsylvania. Plaintiff Shelley realized that he was a TI in 2016. However, he believes his targeting began decades before. Plaintiff Winter Calvert, of legal age, United States citizen, engineer, and a resident of Houston, Texas. On information and belief, Mr. Calvert has been a TI since at least 2011. For over 25 years, and throughout his activism on behalf of targeted individuals that began in 2017, Plaintiff Calvert has been also known as Richard Lighthouse. Plaintiffs Armando de la Torre and his wife Berta Jasmine de la Torre are United States citizens, married to each other, are TIs since 2019. They are residents of Alvin, Texas. They sue on their behalf and on behalf of and custodians of their minor daughter, J.D., born in 2019. Due to her tender age, it is impossible that J.D. could present a national security concern or be a TI. Like her parents, 3-year-old JD is the victim of targeting as described herein and suffers from V2K since at least August 2022. Plaintiff Deborah Joanne Mahanger of legal age, United States citizen, former FBI agent, mother, is a resident of New Hampshire. She became aware she was a TI on or about 2019. Plaintiff Mahanger also appears on behalf of and is custodian for her 8-year-old daughter LAM, who is also a TI. Both been diagnosed with Havana syndrome. 1. Plaintiff Lindsay J. Appen, of legal age, United States citizen, married, real estate broker, mother, United States citizen and resident of Houston, Texas, became aware she was a TI in 2016. Plaintiff Melody Hobson, of legal age, United States citizen, single, mother, resident of Deer Park, Texas, became aware she was a TI around 2020, although she believes her targeting began on or around 2014. Plaintiff Anna Robertson Miller, of legal age, United States citizen, married, paralegal, mother, and resident of Cypress, Texas, became aware in 2016 that she was a TI but believes her targeting could have begun as far back as 2013. In 2019, Ms. Miller began enduring gruesome DEW attacks. Plaintiff Yvonne Mendez, of legal age, United States citizen, single, mother, and resident of Houston, Texas, believes she has been a TI for over 19 years. Plaintiff Devin Delaney Fraley, of legal age, United States citizen, single, mother, resident of San Antonio, Texas, became aware she was T in 2016 but that her targeting began years before. In 2019, she started enduring DEW attacks and experiencing V2K. Plaintiff Susan Olson, of legal age, United States citizen, single, nurse, resident of Fort Myers, Florida, became aware she was a TI in 2015 but recognizes she may have been a TI for a longer time. Plaintiff Jean Kahn, of legal age, United States citizen, single, attorney at law, resident of East Brunswick, New Jersey, became aware he was a TI in 2015, but recognizes he may have been a TI for a longer time. Plaintiff Jason Faust, of legal age, United States citizen, single, anthropologist, resident of Houston, Texas, became aware in 2016 that he was a TI, although he believes his targeting began in 2015. Defendants. Defendant Federal Bureau of Investigation, FBI, is the agency vested with the statutory responsibility of preparing and maintaining the Terrorist Screening Database, TSDB, colloquially known as the watchlist, as well as that of answering Plaintiffs' Privacy Act requests. It is brought as defendant in this case for its failure to comply with the Privacy Act. Defendant FBI is also responsible for creating and maintaining the TSDB, having also the authority to nominate and include individuals thereto. Defendant Department of Homeland Security, DHS, is the agency vested with the responsibility of funding, creating and approving the standard operating procedures implemented in the Fusion Center network under the agency's absolute discretion and control, as well as that of answering Plaintiffs' Privacy Act requests. DHS is made a defendant in this case for its failure to comply with the Privacy Act. Defendant Christopher Wray is Defendant FBI's director, exercising his oversight and control responsibility to ensure regulations and procedures at the Terrorist Screening Center, TSC, and its product, the TSDB, comply with the United States Constitution. He is personally liable to plaintiffs for their nomination to the TSDB, causing and/or enabling the deprivation of their substantive and procedural due process rights contained in the 5th, 6th, and 14th Amendments of the United States Constitution, and, further, by enabling their targeting, unauthorized experimentation and torture in violation of their rights under the 1st, 4th, and 8th Amendments of the United States Constitution, and, further, their right to be free of torture. Under the Convention Against Torture, he is sued both in his official and personal capacity. Defendant Attorney General Merrick Garland is responsible for ensuring all procedures and regulations at FBI and TSC comport and comply with the mandate and protections embodied within the United States Constitution, a ministerial duty he has disregarded in the preparation, maintenance, and use of the TSDB. He is personally liable to plaintiffs for causing and/or enabling the deprivation of their substantive and procedural due process rights contained in the 5th, 6th, and 14th Amendments.
All right, so this is starting to go into detail of each defendant, and he is right here. He is personally liable to plaintiffs. I don't see how they can prove that. then again, I don't know the information that they have. Maybe they have some type of evidence that no other TI have. But this is not a class action. The lawyer said this is a private lawsuit, just with the plaintiff listed above. So it's not a class action. So maybe one of those TIs was able to obtain some type of evidence, but it has to be official evidence. It's not just people's words or what people say. The judge will want to see official evidence, documentations, usually signed by one of these person. Like this person will have to sign off. This attorney general will have to sign off on these orders or some type of official document linking to the plaintiffs. So maybe they somehow was able to obtain that. I don't know.
He is personally liable to plaintiffs for causing and/or enabling the deprivation of their substantive and procedural due process rights contained in the 5th, 6th, and 14th Amendments of the United States Constitution and by enabling their targeting, unauthorized experimentation and torture in violation of their rights under the 1st, 4th, and 8th Amendments of the United States Constitution, as well as their right to be free of torture under the Convention Against Torture. He is sued both in his official and personal capacity. Defendant Charles Cable, Jr. is the TSC's director who develops and maintains the federal government's TSDB, and accepts the nominations of plaintiffs and other similarly situated American citizens made to the federal terror watch list. Defendant Cable also oversees the dissemination of the stigmatizing TSDB label, including plaintiffs, TJ members, and other similarly situated American citizens to state and local authorities, foreign governments, private corporations, private contractors, airlines, gun sellers, car dealerships, financial institutions, the captains of seafaring vessels, among other official and private entities and individuals. Defendant Charles Cable, Jr. has failed to observe plaintiffs' and TJ members' constitutional protections and guarantees. He is personally liable to plaintiffs for causing and/or enabling the deprivation of their substantive and procedural due process rights contained in the 5th, 6th, and 14th Amendments of the United States Constitution. Defendant Cable is personally liable to plaintiffs by enabling their targeting, unauthorized experimentation and torture in violation of their rights under the 1st, 4th, and 8th Amendments of the United States Constitution, as well as their right to be free of torture under the Convention Against Torture. He is sued both in his official and personal capacity. Defendant Alejandro Mayorkas is Defendant DHS Secretary, is responsible for the oversight of his agency's collaboration with Defendant FBI's TSC for the nomination process of individuals to the TSDB. Defendant Mayorkas is also sued in his personal capacity as the official responsible for the supervision and implementation of unconstitutional operating procedures at the national network of fusion centers 3 that implement the illegal organized and systemic surveillance and stalking procedures carried out against plaintiffs and TJ members. He is personally liable to plaintiffs for causing and/or enabling the deprivation of their substantive and procedural due process rights contained in the 5th, 6th, and 14th Amendments of the United States Constitution and by enabling their targeting, unauthorized experimentation and torture in violation of their rights under the 1st, 4th, and 8th Amendments of the United States Constitution, as well as the Convention Against Torture. He is sued both in his official and personal capacity. Defendant Kenneth L. Weinstein is Defendant DHS's Undersecretary for Intelligence and Analysis. He provides the Secretary, DHS senior leadership, DHS components, and state, local, tribal, territorial, and private sector partners the Homeland Security intelligence and information used in their operations. He is sued in his official as well as personal capacity. 3 Congress's definition of fusion centers is a collaborative effort of 2 or more federal, state, local, or tribal government agencies that combines resources, expertise, or information with the goal of maximizing the ability of such agencies to detect, prevent, investigate, apprehend, and respond to criminal or terrorist activity. Implementing recommendations of the 9/11 Commission Act of 2007, PL 110-53, Section 511, 121 Stat 317, 318-24, 2007. http://www.gpo.gov/fsace/package/plaw-publ53/pdf/110publ53.pdf. Since he is responsible for the supervision and control of the organized stalking endeavors carried out against plaintiffs through the National Fusion Center Network. Legal and factual background preamble to this lawsuit. The foregoing allegations are re-alleged and incorporated herein. Plaintiffs served on defendants Garland, Ray, Cable Jr. and Mayorkas a notice of writ of mandamus/demand letter dated December 21, 2022 in an effort to carry out reasonable diligence to prevent the filing of this complaint. See Exhibit 3. Plaintiffs have expended due diligence to unearth the what element and the who element surrounding the targeting program. Defendants' refusal to adequately reply to Plaintiffs' Privacy Act requests constitutes a concealment mechanism directed at preventing them from uncovering the full spectrum of players and critical facts of the secret human experiment known as the targeting program. In an attempt to initiate a non-existent redress procedure, individual plaintiffs served on defendant FBI and defendant DHS Privacy Act requests asking for information about their inclusion in the TSDB under their agency's control. Plaintiffs' requests were sent on the following dates.
So it sounds like they did send out and try to obtain this TSDB documentation, but there was no response from the defendant. So like I mentioned before, they are not going to hand that over. Why would they, if it does exist, and probably it does exist, why would they hand that over and end up paying for damages? They're not going to hand over the list. Would you, if you're in their position? You're not going to. So they don't have the list. So how are they going to prove the plaintiff's name, the TI's name, are on the list when they don't have the list, an official document? How are they going to prove that?
Plaintiff Leonid BR, November 29, 22, FBI, November 30, 22, DHS. B. Karen Stewart, November 26, 22, DHS, January 4, 23, FBI. Dr. Timothy Shelley, December 31, 22, Ustoge, FBI and DHS. Winter Calvert, December 1, 22, FBI, December 2, 22, DHS. Armando Della Torre, November 22, FBI, G. Deborah Mahanger, December 2, 22, FBI, December 2, 2022, DHS, December 3, 2022, Ustoge, H. L. Mahanger, a minor, December 2, 22, FBI, December 2, 2022, DHS, December 3, 2022, Ustoge, I. Anna Robertson Miller. December 4, 22, FBI, DOJ and DHS, J. Melody and Hobson, December 12, 22, FBI, December 30, 22, DHS and DOJ, K. Devin Fraley, December 12, 22, FBI, December 31, 22, DHS, L. Jason Faust, December 3, 22, FBI, DOJ and DHS. Defendant FBI and or defendant DHS refused to produce information in response to Plaintiffs' Privacy Act requests. The defendants either denied having any responsive documents or included a generic GLOMAR denial stating that the agency cannot confirm or deny any of the information requested. Defendants' GLOMAR responses to Plaintiffs' Privacy Act requests constitute a violation of Executive Order 13526 that prohibits the classification of information to conceal violations of law or prevent embarrassment to the agency. Defendant FBI and defendant DHS violated the Privacy Act because even though all of plaintiffs' names are supposed to appear in a subcategory of the TSDB, neither agency admitted this fact or produced any information attesting to it. Defendant's failure to reply to the letter dated December 21, 2022 sent on behalf of TJ and the plaintiffs compelled the filing of this complaint.
Now, I got to tell you guys something about lawsuits. If they did not respond about, if the plaintiff's name are on the list or not, that does not mean that, it's a possibility that they're just hiding the information because the plaintiff's name are on the list. If they don't say anything, that is exactly what it is. They didn't say anything. So it's not a yes or a no. And that's how the court works. The more you say, the more you're going to be held liable. So them not saying anything does not mean, oh yes, does not mean they're guilty, and that it's most likely the plaintiff's name are on the list. It doesn't mean that at all. And if they're not going to present a list during the discovery of evidence phase of the trial, then there is no list. As long as they never said yes that there is a list and their names are on the list, if they don't say that, then you can't assume that the plaintiff's name are on a list. It doesn't work like that.
Complaint. Defendants Interagency Scheme. On September 16, 2003, President George W. Bush issued the Homeland Security Presidential Directive 6, HSPD 6, to develop, integrate, and maintain thorough, accurate, and current information about individuals known or appropriately suspected to be or have been engaged in conduct constituting, in preparation for, in aid of, or related to terrorism. Thereafter, Congress likewise mandated greater sharing of terrorist information among federal departments and agencies, requiring the protection of privacy and civil liberties. HSPD 6 authorized the Attorney General to create the TSC to consolidate the federal government's approach to terrorism screening and to provide for the appropriate and lawful use of terrorist information in screening processes. The TSC is an interagency operation under the control of defendant FBI but also involves defendant DHS and other agencies of the United States government. Under the purview of defendants Ray and Cable Jr., the TSC is responsible for the creation and maintenance of the TSDB, a centralized collection of information to include and monitor known or suspected terrorists, KST, including biographic and biometric data about them. The Terrorist Review and Examination Unit, TREX, within the TSC is the division responsible for carrying out the investigations on people nominated to the TSDB. The TSDB Secret X Part Nominating Process. Defendants Ray and Cable Jr. have a ministerial duty to adhere to the precepts of the United States Constitution upon drafting, maintaining, and disseminating the TSDB. HSPD 6 mandated the implementation of a terrorist screening process for the creation of the TSDB that had to be consistent with the provisions of the Constitution and applicable laws, including those protecting the rights of all American citizens. In order to nominate a subject for entry into the TSDB, the United States Constitution requires that defendant FBI have a reasonable suspicion to believe that the subject is a known or suspected terrorist, KST. When a citizen or resident of the United States is nominated to the TSDB, he or she is not notified of the pending nomination nor afforded an opportunity to challenge it. Fairness can rarely be obtained by secret, one-sided determination of facts decisive of rights. Joint Anti-Fascist Refugee Cum v. McGrath, 341 U.S. 123, 170, 1951, Frankfurter, J. Concurring.
Okay, I just gotta be upfront with you guys. When it comes to accusations like this about how a citizen's being selected and they're not being notified and all this stuff, how would a person know that they're on the list if they're not thinking that way? And when they think that way, where did the idea come from? It came from the lower voice to skull. Okay? And if you do not understand the lower voice to skull, it's fine, because what you're missing is the visual. You need to see it with your own eyes as to whom these gang stalkers are and connect the dot as to how they can generate and manipulate your mind using lower voice to skull. So you're only missing the visual part. And that's what a lot of TIs, even the ones that are really advanced and know what's going on, they're missing the visual part. And I always claim that I know what they look like. It's because by chance, I stumble upon it many years ago. And I've been on that path ever since. So as soon as I show you guys what they look like, it's all going to make sense. This lawsuit here, it's weak. My opinion is weak because they don't have solid evidence. They're making assumptions and they're requesting information that they will not get. So it's not going to stick. But I could be wrong. They might have other documentation that are not mentioned. But so far, up to this point, it's weak. And the plaintiffs are the ones with the burden of proof. The defendants don't have to do anything. They don't have to provide one piece of paper of documentation. The plaintiff have to show up with the actual proof, and it's got to be official documents. And so far, it doesn't seem like they actually have it.
Concurring. Executive Order 13,520 Access Section 1.7 precludes defendants from shrouding with a cloak of secrecy the target experimentation program. This section provides as follows: Sector 1.7. Classification prohibitions and limitations. In no case shall information be classified, continue to be maintained as classified, or fail to be declassified in order to conceal violations of law, inefficiency, or administrative error. Defendant FBI acknowledges that although it is supposed only to nominate subjects of predicated investigations for inclusion in the TSDB, in certain circumstances they will add a person who is not the subject of a predicated investigation because that person allegedly poses a threat. Foreign governments, the State Department, the Central Intelligence Agency, the Defense Intelligence Agency, the National Security Agency, and Defendant FBI and Defendant DHS nominate people for inclusion in the TSDB. Form FD 930, also known as Standard Nomination Form or Standard Nomination Tool, is used by private individuals, corporations, and the intelligence community, to nominate people for the TSDB. See Exhibit 4. By submitting to Defendant FBI a Form FD 930 attached hereto as Exhibit 4 of this complaint, anyone can nominate a person to the TSDB. An identical copy of the Standard Nomination Form is published in the Department of State's Viper Program webpage for the nomination of foreign nationals to the TSDB. Exhibit 5. The Department of State categorizes the Standard Nomination Form as an unclassified / for official use only document. Form FD 930 is not an official U.S. government form since it has not been approved by the United States Office of Documents pursuant to the requirements of the Paperwork Reduction Act of 1995. Form FD 930 does not meet the requirements of the Department of Defense Forms Management Program since it does not meet the requirements of the General Services Administration Standard and Optional Forms Management Program. Form FD 930 is thus an illegal document that is used to nominate and place unsuspecting United States citizens and residents on the TSDB. Pursuant to Federal R.Evid. 201(c)(2) and d, plaintiffs request that this court take judicial notice of the adjudicative fact that the use of Form FD 930 to nominate persons to the TSDB is contrary to law. Form FD 930.
Okay, so let's just say, yeah, this form is illegal. But how are they going to obtain the actual form, the original form that was submitted to them with the plaintiff's name on there? So whomever out there submitted this form, writing down the TI's name, okay, and submitted to this agency and be put into this TSDB database, how are they going to get that original form with their name on it? Because they would need to provide the actual form FD 930 with the plaintiff's name, the TI's name on there. How are they going to get that? If they don't have it, then it doesn't even matter if the form is there or not, because they don't have the TI's name in the database, so they can't prove that they're being surveilled by the agency. You see the correlation here. You see how it just breaks down. How are they going to prove that there is? How are they going to obtain this form with the plaintiff's name, each individual plaintiff's name, or even just one of the plaintiff's name on there?
FD 930 does not provide for any due process safeguards to prevent the inclusion in the TSDB of United States citizens like the named individual plaintiffs, those equally situated to them, and TJ members, despite an absence of links to terrorism. There are no restrictions as to who can fill out and submit Form FD 930 to defendants, regardless of whether the person is a suspected terrorist or not. On information and belief, private individuals, corporations, and foreign governments can submit nominations to defendant FBI or defendant NSA through the TSDB nomination form. The TSDB nomination by private individuals is dangerous and repugnant to the principles contained in the United States Constitution, placing in private hands the capacity to obliterate someone's life for improper motives. Nominations are not supposed to be solely based on race, ethnicity, national origin, religious affiliation, or First Amendment protected activities. 49 U.S.C. Section 114, H. 3. On information and belief, individuals are placed on the TSDB for engaging in the legitimate exercise of First Amendment protected rights, such as whistleblower or journalist activity, as is the case of plaintiffs Karen Stewart, plaintiff Timothy Shelley, and Winter Calvert. On information and belief, other TIs such as plaintiffs Timothy Shelley, Susan Olson, Yvonne Mendez, and Lindsay Penn were targeted after undergoing a contentious divorce, a child custody battle, or the filing of charges against a stalking former spouse. Defendant FBI's and TSC's decision to conclude that a person is a KST that should be on the TSDB must stem from a reasonable suspicion that the intelligence gathered on the nominated person by federal, state, local, territorial, tribal, and international partners.
See, I know TIs are smart people, and TIs are not criminals. Well, we're not. I can't speak for everybody, but I know I'm not a criminal. I mean, I made a mistake in my life, but I don't see myself as a bad person. I'm definitely not a terrorist. And I know TIs are not terrorists, but a lot of TIs believe that it's because maybe they research into certain topics in the past, topics that they shouldn't be looking into. And that's what got them on the list. And right here on just this alone, it says it could be because of a divorce, a child custody battle, or filing charges against a stalking former spouse. Those are accusations. Those are just accusations or assumptions that it's one possibility that these plaintiffs are on the list. And even if the form is submitted, the FBI's and TSC's, they will look into it. Of course they will, because there's both sides of the argument. The list could also be good. If you do believe you have a terrorist neighbor, you probably want to submit the form, right? I mean, you can go both ways. But the FBI and the TSC, they'll investigate. And as a TI, if you're not doing anything bad, and you're not doing anything that's terrorist related, why would they continue doing it to you? Why would they surveil you like that? It just doesn't make any sense. That's because the government are not involved. The gang stalkers control the government. The gang stalkers can manipulate anyone's mind. The gang stalkers control the world. They are aliens. I will show you, because what you're missing is just the visual part. You just need to see with your own eyes. That's why you can't bypass that understanding, that blockage of aliens. Like, in your head, you can't do it because you haven't seen it. But as soon as you see it, and I explain it to you, it will make sense.
supports the conclusion that the individual engages in, has been engaged, or intends to engage, in conduct constituting, in preparation for, in aid or in furtherance of, or related to, terrorism and or terrorist activities. Defendant FBI doesn't carry out the investigation on the individual nominated to the TSDB. Instead, defendant FBI delegates this endeavor to the nominating agency or instrumentality in private companies such as the Leidos Company that has been known to corroborate NIS information. A 2009 audit report by the USDOJ Inspector General's Office concluded that many of the nominations submitted directly to were processed with little or no information explaining why or how the subject may have a nexus to terrorism, also known as derogatory information. Point 4. Approval of a nomination to the TSDB does not require concrete facts. The 2013 watch listing guidance specifically provided as follows: in determining whether a reasonable suspicion exists, due weight should be given to the specific reasonable inferences that a nominator is entitled to draw from the facts in light of his/her experience and not on unfounded suspicions or hunches. Although irrefutable evidence or concrete facts are not necessary, to be reasonable, suspicion should be as clear and as fully developed as circumstances permit. Emphasis hours. The watch listing guidance document includes in its definition of terrorism any act that is dangerous to property and intended to influence government policy through intimidation. The standard to include anyone in the TSDB and secretly submit them to a permanent life of illegal torture, persecution, and surveillance is unconstitutionally vague. To meet the reasonable suspicion standard, the nominator, based on the totality of the circumstances, must rely upon articulable intelligence or information which, taken together with rational inferences from those facts, reasonably warrants a determination that an individual is known or suspected to be or has been knowingly engaged in conduct constituting, in preparation for, in aid of, or related to terrorism and or terrorist activities. Emphasis hours. The particularized derogatory information used to accept, reject, or modify the nomination of a person into the TSDB is supposed to contain an objective factual basis linking the individual to terrorism or terrorist activities. The particularized derogatory information to include the following: an individual's race, ethnicity, religious affiliation, beliefs, and activities protected by the first 4C. The Federal Bureau of Investigation's Terrorist Watch List Nomination Practices, U.S. Department of Justice Office of the Inspector General Audit Division, Audit Report 09-25, May 2009. Amendment, such as freedom of speech, free exercise of religion, freedom of the press, freedom of peaceful assembly, and the freedom to petition the government for redress of stress of grievances, travel history, associates, business associations, international associations, financial transactions, and or the study of Arabic. The particularized derogatory information standard requires that defendant FBI have articulable intelligence or information which, based on the totality of the facts, and taken together with rational interference from those facts, warrants a determination that the subject is known or suspected to be, or has been, knowingly engaged in conduct constituting, in preparation for, in aid of, or related to terrorism or terrorist activities.
Okay, I gotta pause here. Notice I gotta make a mention. So they use study of Arabic as a reason, okay, as one of the reasons, or travel history, associates, business associations, international associations, financial transactions, or study of Arabic. That is a huge range of assumptions. Just like the TI community, majority TIs are confused at whom these gang stalkers are. I mean, there are facts, okay? They know there's something going on. That's a fact, okay? Gang stalking, something's going on. But what's missing is just whom are these gang stalkers? And since the TI community do not know who these gang stalkers are, TIs will start having make up their own assumptions as to whom they are. And like I've been teaching you guys, the lower voice to skull will use what you know against you because it knows our thoughts. It feeds us ideas. So when you believe, oh, it's because let's say a TI out there believe that they're being targeted because they're studying Arabic. That idea that they believe, oh, because they just started studying Arabic and now they're a TI, that idea came from the lower voice to skull. The idea that because the TI traveled to a certain country, right, had a certain types of travel history, and now they're a TI, that idea came from the lower voice to skull. Or the TI believing a business association with some company or some international association with an international company, and now they're being targeted. That idea came from the lower voice to skull. You start to understand now. And that's why in the TI community, majority of people have their own idea, but they can't pinpoint it. It's because they're being blocked from critical thinking to understanding that they have no evidence and they don't have the information to pinpoint it. I don't have the information, but by chance I stumble upon it many years ago. Okay? So it's not like I am smarter than all the other TI. It's just by chance I stumble upon it. And what I know, I have not seen any other TI brought this up. So in 2 months, I will show the entire TI community. I will show the world. And once you get the visual, you will understand. Even the skeptics will understand because I will show it to them, and you can't deny what you see with your own eyes. That's why in my last video, video 39 of Truth of Gang Stalking, I mentioned it's observations. And observations are facts because you see it. I'm not just going to show you photos, I'm going to show you videos. I'm going to show you historical documents. I will show you my personal experience and how what I experienced is connected to all these other information I will show you. I will show you how where I live right now, those gang stalkers are everywhere. I will show you this. It will make sense. But this lawsuit itself doesn't make any sense. And I'm confident of that. The gang stalkers control this world. They're in people's mind. They feed us ideas. And I will show you what your gang stalkers look like through visuals. I will show you. I will explain to you.
Activities. Former TSD Deputy Director Timothy Groka's statement under penalty of perjury given in the context of a judicial procedure stated that TSDB includes identifying information of certain individuals who are not categorized as known or suspected terrorists. Plaintiffs request that this court take judicial notice of TSC Deputy Director Timothy Groka's statement under penalty of perjury asserting the following: limited exceptions to the reasonable suspicion standard exist for the sole purpose of supporting certain special screening functions of DHS and state, such as determining eligibility for immigration to the U.S. Individuals included in the TSDB pursuant to such exceptions are not considered known or suspected terrorists and are not screened as such. As a result, any U.S. person who is in the TSDB pursuant to an exception to the reasonable suspicion standard would not be required to undergo heightened aviation security screening at airports on that basis, but could be selected for other unrelated reasons, such as random selection. Emphasis hours. See Exhibit 2. Including in the TSDB persons that are not known or suspected terrorists is a violation to the Administrative Procedure Act's prohibition on arbitrary government action contained in 5 U.S.C. Section 706. Despite an absence of particularized derogatory information linking plaintiffs and TJ members to terrorism, their names figure in the TSDB. The TSDB's inclusion standards are so permissive and pliable that they violate plaintiffs and TJ members, Procedural and substantive due process rights. Vetting of nominees. Defendant FBI subcontracts to private corporations like the Leidos Corporation the task of corroborating non-investigative subjects' personal information upon their nomination to the TSDB and/or their vetting process. The TSC has no quality control procedure in place to specifically confirm that a person is a known or suspected terrorist, KST, or non-investigative subjects, NIS, since they rely on the facts and investigation that the nominating agency provides. Private corporations known as watch listing cells serve as contractors to defendant FBI and/or defendant NSA for obtaining and corroborating the personal data on individuals to be included in the TSDB. These entities limit their verification to personal information such as names, residential address, contact information, and relatives. The private contractors that check the information on individuals nominated to the TSDB do not confirm whether the nominee is a known or suspected terrorist. The TSDB subcategories. The TSDB contains a series of subsets of categories that differentiate individuals on the list pursuant to the degree of threat they pose and pursuant to the grounds for their inclusion on the list. Official U.S. government, defendant FBI, and defendant DHS documents and/or statements under penalty of perjury establish that there are conflicting versions of what the categories within TSDB are. Pursuant to defendant DHS regulations published in 81 Federal Register 19989, the categories of individuals covered by the TSDB include individuals known or suspected to be or have been engaged in conduct constituting, in preparation for, in aid of, or related to terrorism, known or suspected terrorists. Individuals who are foreign nationals or lawful permanent resident aliens and who are excludable from the United States based on their familial relationship, association, or connection with a known or suspected terrorist as described in Sector 212A, 3B of the Immigration and Nationality Act of 1952, INA exceptions. Individuals who were officially detained during military operations, but not as enemy prisoners of war, and who have been identified to pose an actual or possible threat to national security, military detainees, and individuals known or suspected to be or have been engaged in conduct constituting, in aid of, or related to transnational organized crime, thereby posing a possible threat to national security, transnational organized crime actors. Conversely, defendant FBI regulations published in 70 Federal Register for 3716 list different categories of records within the TSDB as follows. Individuals known or appropriately suspected to be or have been engaged in conduct constituting, in preparation for, in aid of, or related to terrorism, known or suspected terrorists. Individuals identified during a terrorist screening process as a possible identity match to a known or suspected terrorist. Individuals who are repeatedly misidentified as a possible identity match to a known or suspected terrorist, misidentified persons, and individuals about whom a terrorist watch list related redress inquiry has been made. Recent defendant FBI agents' declarations and statements under penalty of perjury given in the El Hadi case, Supra, challenging the TSDB's watchlist component provide yet another version of the categories within the TSDB. Handling Code 1 Outstanding Arrest Warrant Handling Code 2 Under Active Investigation Handling Code 3 Individual has possible ties to terrorism Handling Code 4 Identity provided has possible ties to terrorism. See Exhibit 5. The first two categories are commonly referred to as known and suspected terrorists and include the selectee and no-fly lists. Inclusion on the first two subcategories of the TSDB, no-fly or selectee lists, requires additional substantive derogatory criteria. On information and belief, the expanded selectee list consists of individuals for whom the TSDB record contains a full name and a full date of birth but lacks sufficient derogatory information linking the person to terrorism so as to categorize him or her as a KST. Known terrorists for whom there is an outstanding arrest warrant are grouped under TSDB's Handling Code 1 category, also referred to as the no-fly list. A known terrorist is an individual who has been a. arrested, charged by information, indicted for, or convicted of a crime related to terrorism and/or terrorist activities by U.S. government or foreign government authorities, or b. identified as a terrorist or a member of a terrorist organization pursuant to statute, executive order, or international legal obligation pursuant to a United Nations Security Council resolution.
You know, On this mention of known terrorists for whom there is an outstanding arrest warrant are grouped under TSDB's handling code 1 category, also referred to as no-fly list. This is unnecessary because this does not support their claim. These are just information that's irrelevant unless the plaintiff is on a no-fly list. And if they're on a no-fly list, there's a strong reason behind it. Right here, one of them is outstanding arrest warrant. Well, if the TI has an outstanding arrest warrant, yeah, it's understandable that they're on a no-fly list. But probably majority of the TIs are not on that no-fly list. So I don't even know why they want to put this in there to make it sound like it's such a big thing and it's correlated with the TIs, the plaintiffs. A lot of these information are just jargon. It's a bunch of speculations. And they keep talking about this list and the detail of the list when they don't even have the list. They don't even understand how the lists work. But then they describe it as if they actually have the list in hand and the functioning of the operation of these agencies. This is starting to get into the jargon territory. And this does not look good. And it just seems all over the place now. It's starting to get off topic. And I would imagine more exhibit, meaning more proof. But it's just, I do not feel like they have a case. This is just going to run up the bill. It's going to cost a lot of money.
Resolution. Any individual, regardless of citizenship, may be included on the no-fly list when the TSC determines the individual meets additional criteria in at least one of the following criteria, where the individual poses a threat of committing an act of international terrorism, as defined in 18 U.S.
See, I know TIs are not interested in international terrorism. TIs are not interested in international terrorism. So this no-fly list doesn't make any sense. But if you're a TI and you're on the no-fly list, then you should already know why you're on that list. You don't need to make assumption.
As defined in 18 U.S.C. Section 233(1)(1), or domestic terrorism, as defined in 18 U.S.C. Section 2331(5), with respect to an aircraft, including a threat of piracy, or a threat to airline, passenger, or civil aviation security. A threat of committing an act of domestic terrorism, as defined in 18 U.S.C. Section 233(1)(5), with respect to the homeland. A threat of committing an act of international terrorism, as defined in 18 U.S.C. Section 233(1)(I), against any U.S. government facility abroad and associated or supporting personnel, including U.S. embassies, consulates and missions, military installations, as defined by 10 U.S.C. 281(c)(4), U.S. ships, U.S. aircraft, or other auxiliary craft owned or leased by the U.S. government, or a threat of engaging in or conducting a violent act of terrorism and who is operationally capable of doing so. Although mere guesses or hunches are not enough to constitute a reasonable suspicion that an individual is a suspected KST, concrete facts are not necessary to include someone in the TSDB. 5. The TSDB's second category is known as the Handling Code 2 or Selectee List. The Selectee List comprises the names of suspected terrorists under active investigation. A suspected terrorist is an individual who is reasonably suspected to be engaging in, has engaged in, or intends to engage in conduct constituting, in preparation.
Targeted patent A. It does sound like I don't want this suit to be possible, but this suit's already happening. I'm just stating facts. I mean, when you get the idea of that came from your lower voice to skull. What I'm saying are facts. And I'm not in the lawsuit. I'm not an attorney, so I can't influence the lawsuit. They already filed it. If it happens, it happens. I cannot change the outcome, but I'm just stating facts because I know this is jargon. I know the gang stalkers are not the government agency. The gang stalkers are aliens. And if you don't know, that's because you haven't seen it with your own eyes. And that's why I will show you. Once I show you, it will make sense.
Preparation for, in aid of, or related to terrorism and/or terrorist activities.
Targeted pen, you're right. We got to have hope and we got to stay positive. And, sometimes I really have to hold it back because for 2+ years now, I've been making videos and, it's hard for me to keep it in, because I want to tell you guys the information, but yet I also want you guys to see the full picture and that I'm not just talking out of my behind. And like I mentioned before, this is my journey. This is how my journey unfolds. You have your own journey. And my intention is good, is to help the TI community. But when it comes to lawsuit like this, since I know what I know, it's a waste of money. But if you feel like you have to file a lawsuit, then go ahead and do that, because only that way will you actually satisfy your own mind. Because if you're thinking about a lawsuit and you're not doing it, then the lower voices skull will constantly use it to make you feel sad that you didn't hire an attorney. So if you feel like you need to hire an attorney and file a lawsuit, then maybe you should do it. So you at least you experience and know the outcome of it. But I'm just saying, because I hired a lawyer before in the past, and I like forensic files and all those documentaries. So the court system is just, it needs to provide proof as plaintiffs, and the TIs, based on what's happening, based on this information right now that I'm showing you guys, the plaintiffs don't have the evidence. They will request the evidence during discovery from the defendant, and the defendants will not provide it. They will not. The judge will want to see documentation, official documentation, with the plaintiff's name on them, and somehow those defendant will, with their signature on those documentation, connecting them to these type of claims that the plaintiff are making, saying the defendant are part of what's happening, and the reason why these plaintiffs are being gang stalked and tortured. There needs to be a strong connection, and this evidence is not there. They will ask for it, but they won't get it. So all this is just jargon. It's starting to get off topic now.
On information and belief, the individuals in the no-fly and selectee list components of the TSDB encounter obstruction of travel at United States ports of entry and are the only ones that may submit a redress request for removal from the list. The no-fly and selectee lists are commonly known as the watch list, comprised of KST. There is another category of individuals included the TSDB, that of persons who 5-HTTP://archive.today/2015.2002/https://theintercept.com.
Yes, target pattern, it does bring up awareness. Open format to the public. You're right about that one. And yeah, Danielle, they did sign treaties saying they wouldn't torture humans. All those are true. On this specific lawsuit, they're making those claims. They're just saying those things. Okay, it's true. A lot of it are true of how these things shouldn't torture humans and the way it functions. But the plaintiff are suing these agencies and suing these directors from these agencies. So the plaintiffs need to make the connection as to why they are being proving their claim of them being targeted and them being tortured. That's what I'm trying to say. That's just how the court works. The judge is the middle person. The judge wants to see solid proof. So the plaintiffs are making all these claims, but the plaintiffs are the ones that needs to show the proof. The plaintiffs have the burden of proof. And from earlier, this text document mentioned the database and mentioned a list that the plaintiff's name are on the list, but they do not have the actual list. They request for information, but there was no answer from these departments. And that's why they feel like it's enough for them to file this complaint. But they don't have the actual list with the name of these plaintiffs. So when that's not available and they try to accuse the defendant of putting them on the list, that is not going to work. That is just the way the court system works. I'm okay with lawsuit. If you have the evidence, definitely file the lawsuit. But do you have the evidence? That's all I'm trying to say. And the ones that are going to really make out of this are the attorneys. The attorneys are the ones going to make a lot of money out of this.
http://archive.today/2015.1.2321022/https://the-intercept.com/20155.10.25-23/blacklisted do not meet the substantive derogatory criteria. They are grouped into handling codes 3 and 4. Handling code 3 is also known as the expanded selectee list. According to defendant FBI, handling code 3 comprises individuals with possible ties to terrorism. Pursuant to the FBI handling code 4 comprises people whose identity provided has possible ties to terrorism. On information and belief, the individuals included in the TSDB who are not considered known or suspected terrorists and are not screened as such are also referred to as NIS, are grouped in the categories labeled as Handling Code 3 or Handling Code 4. TSDB's Handling Code 3 and Handling Code 4 comprise individuals who do not meet the criteria required for Handling Code 1 or 2 and are referred to as NIS. Former TSC Deputy Director Timothy Mr. Gross stated under penalty of perjury that any U.S. person who is in the TSDB pursuant to an exception to the reasonable suspicion standard would not be required to undergo heightened aviation security screening at airports on that basis. See Exhibit 5. This is the reason why all but 2 plaintiffs found out that their names had been included in the TSDB's NIS/Handling Code 3/4 lists. Since they do not represent a real terrorist threat, they do not face undue hardship when traveling. Since NIS do not encounter obstacles when traveling, they seldom find out that they are on the TSDB. NIS are allowed to travel without additional burdens or obstacles because they pose no terrorist threat. Informing TIs of their inclusion in the TSDB would grant them the mechanism of seeking redress to remove of their names from it. On information and belief, the only information required to include a NIS in the TSDB is his or her first and last name and any date of birth. Based on defendant FBI's own statistics, 97% of the persons listed on defendant FBI's TSDB are not terrorists. Exhibit 5. Only the first 2 components of the TSDB, Handling Code 1 and Handling Code 2, make up the watch list that contains the names of the KST. When intervening with a non-investigative subject during a routine situation, law enforcement officials are forbidden from telling the individual they are on the list. The TSC includes within the National Crime Information Center's NCSC database the watchlist subset of the TSDB comprised of KST included in the no-fly and selectee list. NIS are not included in the watch list. NIS are not listed in the NCIC. The NCIC is a compilation of 14 person files or categories. To wit, 1. KST file, the known or suspected terrorist, KST file, which is populated with a subset of TSDB information. 2. Supervised release. 3. National Sex Offender Registry. 4. Foreign fugitive. 5. Immigration violator. 6. Missing person. 7. Protection order. 8. Unidentified person. 9. Protective interest. 10. Gang. 11. Wanted person. 12. Identity theft. 13. Violent person. And 14. NICS denied transaction.
Now, I know majority TIs are none of these. Okay, majority TIs are in none of these categories. And possibly not on even one of those claims, okay? One of these reason to be on a list or categories. And I know I have not done anything bad as a person to be gang stalked. And I know a lot of you out there agree. Like I've been telling you guys, TIs are special. The gang stalkers hit the jackpot when they found you because you can hear them. You can communicate with them. You are the bridge. In Tibet, we are considered oracles. I made mention of that in the past. And for those of you that do not believe in any of that stuff, well, you're not being fair because have you done your 20 hours of solid research? I talked about this many times. If you don't believe in that stuff, that's fine. But just be fair. Don't just say no, it's not real. It's okay for you to say you don't know. That's a fair answer. But for you to say no without researching into it, then that is wrong. And once you research into it, okay, I mentioned 20 solid hours. Okay, only you would know if you have done that. Have you done 20 solid hours looking into the unexplained, the spirit side? You will know. You should know. Unless you're just not paying attention during those 20 hours. There's just too much information in it from people around the world, from different time in history, for you to discredit the existence of these unexplained spirits or spiritual paranormal. They're very real and they're in the physical world with us. They are manipulating and also helping us without us realizing they're there. They are very much part of society. And even you have seen them on in TV shows and in movies. Just like how I have seen them in movies in the past, but I never ever think much about them. But once I stumble upon their true identities, now every time I see them in TV shows and in movies, I have to pay attention to them. It triggers something in my mind because now I know what they are. But before I knew what they are, I've seen them in movies in the past. And it didn't even do anything to me. I didn't even care. I don't even think twice about what they are. And once I show you, you will know. And from that moment forward, you'll realize they've been there the entire time.
Transaction. The NCIC also includes 7 property files containing records of stolen articles, boats, guns, license plates, parts, securities, and vehicles. The NCIC does not include the TSDB's NIS/handling codes 3/4 lists because the people listed in them don't constitute a terrorist threat. United States citizens included under Handling Code 3/4 or non-investigative subjects have no available mechanism or formal procedure to challenge their secret inclusion on the TSDB because they are prohibited from discovering their status. Impact to United States citizen or residents upon being secretly listed. On information and belief, those included in the TSDB's NIS/handling codes 3/4 lists are unwilling participants in an experimentation and torture program and are known as targets. A target in the TSDB's NIS/handling codes 3/4 lists is also referred to as a targeted individual. Once an individual has been placed on the TSDB's NIS/handling codes 3/4 lists, his or her name lingers on it indefinitely and/or permanently. A person's permanent inclusion in the TSDB's NIS/handling codes 3/4 lists is the equivalent of an unconstitutionally perennial designation as a person of interest, depriving them of their presumption of innocence and right to procedural and substantive due process. NIS have no means of redress to remove their names from the TSDB's handling codes 3/4 categories. The inclusion of the individuals in the TSDB constitutes the kind of government stigmatization that broadly precludes individuals or corporations from a chosen trade or business and also deprives them of liberty in violation of the Due Process Clause. Trifax Corporation v. District of Columbia, 314 F.3d 641, 644, DCCR 2003. The lack of a viable mechanism to remove a wrongfully listed United States citizen in the TSDB ensures his or her inclusion on it becomes indefinite and/or permanent. Once an NIS is listed in the TSDB's NIS/handling codes 3/4 lists and in violation of the First, Fourth, Fifth, and Sixth and Eighth Amendments to the United States Constitution, defendants order and/or facilitate state, tribal, and federal agencies to constantly track and carry out his or her physical and electronic surveillance and psychological torture. Defendants' illegal and harmful disclosure of false personal information. The TSDB does not contain classified national security information. TSDB information is for official use only // law enforcement sensitive. The label for official use only // law enforcement sensitive means that the information is protected from disclosure and is accessible only to persons who have an official need to know, such as federal law enforcement officials for their screening and vetting activities. Unauthorized disclosure of an individual's inclusion in the TSDB is prohibited under the Privacy Act.
Okay, this contradicts why they filed the lawsuit, okay? It just says it right here, unauthorized disclosure of an individual's inclusion in the TSDB is prohibited under the Privacy Act. So they're trying to get this list to be authorized, and the person in charge of the department did not respond to their complaint or did not respond to the request. So that is the reason as to why they wanted to file this lawsuit. Now, what would be considered a reasonable disclosure? So that is up to the defendants to explain, if they decide to explain. And whatever they say are considered facts, because the plaintiff will have to prove that what they're saying is wrong. I don't even know how, because they're not even in the department. They're not there for the day-to-day function. But yet, when they ask the defendant how it works, the defendant can say, oh, there's no list, or briefly explain how it works. But it's not going to be like what they claim here, in the original complaint. The defendant are not going to show up to court admitting that they're guilty. So even if you believe they are guilty, they're not going to do that. That's why I'm trying to say this lawsuit, it's just benefits the attorney. And lawsuits like this, for TIs, there's really no need. Once I show you all this lawsuit is just nonsense. It's nonsense. And all this information, it's really going off topic. because it sounds really bad what they're doing, but all they have to say is, yeah, they're for terrorists. And there are real terrorists out there. Am I correct? There are real terrorists. TIs are not terrorists. I already know that. But then there are real terrorists out there. So all this stuff they're listing, it sounds really bad what these agencies do, but all they have to say is for terrorists, and that's that. What, you don't want them to not be there so the terrorists can just do whatever they want? No one's gonna want that. That's why it's important to have evidence with the plaintiff's name on there, official form, official documents with the plaintiff's name on there, and they don't have it. Because if they do, they don't need to go into all these explanation and assumptions. They don't. They'll just have something like, oh, see exhibit. So in what exhibit number, this and that. And the attorney, I don't even know if she's a trial attorney. There's attorneys, okay, there's a lot of attorneys out there, okay? Not all attorneys wants to take cases to court. A lot of them don't. A lot of them don't have experience in a trial with juries and stuff in front of a judge. Usually cases, they'll try to get it settled before seeing a judge. And a lot of attorneys are trying to do that. They'll file these complaints and they'll try to get a settlement before seeing a judge, because not every attorney is qualified to go to trial.
In violation of such policies, defendant FBI and TSC distribute the TSDB to at least 18,000 state, local, county, city, university and college, tribal, and federal law enforcement agencies and approximately 533 private entities through its National Crime Information Center (NCIC) system. The list is also shared with more than 60 foreign governments and private entities such as the following: private correctional facilities, private security services for governmental facilities and hospitals, companies providing criminal justice dispatching services or data processing/information services providing services to governmental criminal justice agencies, private probation and pretrial services companies, private city attorneys, a private police department for an airport, a private police department for a transportation authority, private police departments for 2 private incorporated communities, an inmate transport service, an entity that provides forensic services to detect and identify criminals, court constable services, and animal shelters. In 2019, defendant FBI publicly acknowledged it shares the TSDB with 1441 non-government entities. These include private employment, background check, and credit agencies. Defendants widely disseminate the TSDB among citizen policing organizations such as InfraGard and Citizen Corps that perpetrate illegal/rogue vigilante conduct against NIS under the pretense that they are KST. Defendant Majorcas is responsible for the enactment and implementation of highly unconstitutional operating procedures throughout the national network of fusion centers that have carried out the illegal surveillance, organized stalking and psychological torture of plaintiffs and TJ members. Prior legal challenges to the TSDB. Disclosure of TSDB information inevitably occurs when a known terrorist included under its handling code 1 no-fly list, or a suspected terrorist included under its handling code 2 selectee list, encounter problems when attempting to board a plane or a ship. The secrecy veil of watchlisting gets pierced at the airport or ports when any KST attempts to travel when the Transportation and Safety Administration intervenes with the person during pre-boarding screening. The myriad of travel obstacles that KST have encountered as a result of their inclusion in the watchlist component of the TSDB, no-fly and selectee lists, since its inception has prompted legal challenges and congressional mandates. Prior legal challenges to the TSDB have only involved people listed as KST in the TSDB's watchlist whose right to travel has been impaired. As a reaction to the disruptions to United States citizens' travels resulting from their inclusion in the TSDB, Congress enacted acts and regulations to incorporate due process guarantees to the individuals listed in the no-fly and the selectees lists. 49 U.S. Code Section 44926 provides for the appeal and redress process for passengers wrongly delayed or prohibited from boarding a commercial aircraft because they have been wrongly identified as a threat.
Now you need to understand, okay, what they're saying here. Okay, all these are true. Okay, you can say they're true, but it still comes down to the very core of the evidence: the name of the plaintiff on the list. Do they have that evidence? They need that official evidence with the plaintiff's name on them. That is the core, the very base of evidence they would need to support their claim. Because this other stuff here, okay, they're facts, and it happened to other people in the past. That's fine. And I don't know the background of those other people, why they're on the no-fly list. I don't know. But this case, it's the plaintiffs, the people's name under plaintiffs, or their name on the list, and they need this list with their showing their name on it. Do they have that? That is the solid evidence that they need. And so far, they have not convinced me that they have it.
Threat. 49 U.S.C. Sections 44903J2C3I gives the Transportation and Safety Administrator the obligation to establish a procedure to enable airline passengers who are delayed or prohibited from boarding a flight because the advanced passenger pre-screening system determined that they might pose a security threat, to appeal such determination and correct the information contained in the system. TSA implements this mandate through DHS TRIP, which serves as a single point of contact for a wide variety of complaints and inquiries regarding travel difficulties. 49 U.S.C. Sections 44903J2GI provides that the administrator shall establish a timely and fair process for individuals identified in the no-fly and selectee lists to appeal to the Transportation Security Administration the determination and to correct any erroneous information. On information and belief, when the TSC receives a redress petition channeled through the TSA or the FBI's Congressional Office, defendant FBI relays the investigation on whether it is current, relevant, trustworthy, and valid of the derogatory information on the individual to the same federal, state, local, territorial, tribal, and international partner that nominated the person in the first place. Pursuant to the TSC Redress Program SOP, no one at the FBI, TSC, or TREX intervenes in the independent processes undertaken by TSC's federal, state, local, territorial, tribal, and international partners in response to a redress inquiry. In other words, in the course of the existing redress proceedings that do not cover individuals listed under NIS/Handling Code 3/4, the TSC delegates to and does not interfere with the nominating agency or entity the investigation on the validity and accuracy of its own criteria of nominating the person petitioning for removal from the TSDB. Thus, TSA redress involves little more than returning the nomination to the original nominating agency, who routinely reaffirm it. There is no meaningful, independent review of the challenge. A December 8, 2005 Washington Times article reported that the Transportation Safety Administration admitted to Congress that out of the 30,000 airline passengers that had requested so far from the Department of Homeland Security Department to remove their names from TSDBs, only 60 or less than 0.02% had been successful. The redress procedures set forth in paragraphs 170 to 173 above are limited to those individuals that are KST and thus encountered obstacles in the course of traveling, giving them an opportunity to challenge their wrong or mistaken inclusion in the TSDB through the redress procedures currently in place. On information and belief, no court has had to adjudicate a case or controversy involving the constitutionality of the TSDB as it pertains to NIS and or Handling Code 3/4 categories. The TSDB as an unconstitutional blacklisting mechanism of individuals. Aside from not notifying individuals in the United States of their nomination and inclusion to the TSDB, United States NIS and the TSDB aren't afforded a procedure to contest or challenge their nomination because it doesn't exist. The only redress procedure that exists is contained in the TSC's Redress Standard Operating Procedures dated December 8, 2015. According to the TSC's Redress Standard Operating Procedures Manual dated December 8, 2015, Redress the process whereby an individual may seek the help of the screening agency in addressing the cause of an adverse screening experience or outcome related to the use of the TSDB data by filing an inquiry with the screening agency or DHS Traveler Redress Inquiry in cooperation with the TSC and the nominating/originating agency, provides assistance by determining the case if the adverse experience, verifying that all relevant information relied upon in the screening process is current, accurate, and thorough, and making any warranted corrections to pertinent records. The redress process as defined in this paragraph does not apply to inquiries related to government processes unrelated to the mission of the TSC. Pursuant to Redress Operating Procedures Manual, the TSDB is a sensitive but unclassified database and does not contain any derogatory information.
DeAndre, no, I believe you when you recorded them shouting at you at the soccer game. I totally believe you. And I also believe it was the environmental voice to skull, which means everyone in the area can hear it. But that's one of their trick. They like to blend in when there's a large crowd of people. When someone yell, I mean, people ain't gonna think much into it, right? But since you recognize their voice, you already know it's them. You know, and I believe you. People in the environment in your area, I believe they also heard it. But since they're not TIs, true TIs, they're just gonna think it's someone, a fan that's watching. They're not gonna actually look and pinpoint what's going on. But I believe you.
Information. In June 2016, Kelly and Beresky, Department of Homeland Security's then Deputy Assistant Secretary, testified under oath before Congress that there's not a process afforded a citizen prior to getting on the list. Pursuant to Federal R.Evid. 201(c)(2) and d. Plaintiffs request that this court take judicial notice of this adjudicative fact. Defendants have deliberately...
All right, I'm just going to let this play out. I have to take a break. I need to get some water. I need to take a break from this. So I'll just let it play out, okay? There's still a lot more to it. If you want to listen to it, go ahead. But I'll be back.
Deliberately concealed plaintiffs and TJ members' inclusion in the TSDB's Handling Code 3 or non-investigative subjects categories. Defendants' lack of notice to plaintiffs and TJ members of their inclusion in the TSDB prevented them from discovering that they had sustained an injury susceptible to redress. The legal provisions available to individuals in the watch list to seek redress from their inclusion in the TSDB are not available to those in the NIS/Handling Code 3/4 lists. TSDB's unconstitutional bloating, the numbers do not add up. Defendant FBI and NSA statistics regarding the number of records in the TSDB that relate to actual KSTs as explained below demonstrate that in the United States there are hundreds of thousands of individuals that A. are not KST, B. were nonetheless secretly and perpetually included in the TSDB, and C. have no legal recourse for their names removal therefrom. The contradictions between official government sources regarding the TSDB's records are obvious. And the numbers do not add up. The Department of Justice's Office of the Inspector General's May 2009 Audit Report 09-25, the Federal Bureau of Investigation's terrorist TSDB nomination practices found that 35% of the nominations to the lists were outdated, many people were not removed in a timely manner, and tens of thousands of names were placed on the list without an adequate factual basis. In 2008, Rick Kopel, Principal Deputy Director of Defendant FBI Terrorist Screening Center, appeared before the House Homeland Security Subcommittee on Transportation Security and stated that the TSDB contained approximately 1 million records relating to 400,000 individuals, of whom 3%, 12,000, were U.S. persons. U.S. persons, as defined in Executive Order 12333, are U.S. citizens and legal permanent residents. Conversely, 8 years later, the Vice Chairwoman of the Senate Intelligence Committee, Senator Dianne Feinstein, ascertained in 2016 that there were over 1 million records in the TSDB, but only 5,000, 0.5% or 1/200th, of them were Americans. 0.6. On September 2014, Transportation Safety Administration's Christopher Pajota testified before the House of Representatives Subcommittee on Transportation Security that by 2013 the TSDB had 500,000 records, and in 2014 the list contained 800,000 identities. Mr. Pajota's testimony confirmed that an estimated 300,000 additional records were included in the first 9 months of 2014 for an average of 33,333 new individuals added per month. In 2014, Mr. Pajota testified that the 8% of the 800,000 identities in the TSDB were 64,000 were in the no-fly list or handling code 01. Thereafter, former Deputy FBI Director Timothy P. Groh stated under penalty of perjury in El Hadi v. Pajota, 303F.sub.3d 453, 2017, that there were approximately 1.16 million persons in the TSDB and that only approximately 0.5%, fewer than 5,000, of those were U.S. persons. 0.7. A 2007 GAO report found that TSC rejects only approximately 1% of all nominations to the TSDB. However, in the discovery under penalty of perjury produced in the El Hadi case, defendants submitted the table below including the data regarding nominations, acceptances, and rejections. When subtracting the additions and rejections to the number of nominations, 6 http://archive.today/2023.011.07944/https://lawandcrime.com/video/details-fbi-watch-lists-revealed- including number of Americans included /7 there is a large number that remains unaccounted for. TSC audits of defendant FBI produced additional information asserting that approximately 3% of the TSDB is designated as handling code 1 or 2. The remaining 97% is designated as handling code 3 or 4. On March 11, 2019, Mr. Groh declared under penalty of perjury that U.S. persons, citizens and lawful permanent residents, make up less than 0.5%, i.e., 1/200th, of the identities in the TSDB. Exhibit 5. The vertiginous increase in the number of people included in the TSDB reflects Defendant Ray's and Defendant Cable's and their predecessors' failure to adhere to constitutional precepts, the law, and Defendant FBI's own standards and procedures. FBI's reckless, unconstitutional and illicit approval of nominations to the TSDB results in the inclusion of an estimated 98.9% of the people nominated to it. A 2007 United States Government Accountability Office report to congressional requesters entitled Terrorist TSDB Screening: Opportunities Exist to Enhance Management Oversight, Reduce Vulnerabilities in Agency Screening Processes, and Expand Use of the List, found that TSC rejects only approximately 1% of all nominations to the TSDB. In the El Hadi v. Cable case, Customs and Border Protection admitted that it has never publicly identified an act of terrorism that the TSDB helped prevent. Defendant FBI representatives in the El Hadi v. Cable case admitted that they were unaware of a single act of terrorism halted due to the TSDB. The 2007 GAO report determined that 45% of the TSDB records related to redress complaints reflected that the information on the individuals used to include them on the list was inaccurate, incomplete, outdated, and/or that they had been incorrectly included. The disclosure of the TSDB beyond the TSC. Including a person in the TSDB constitutes the targeting of an individual within the United States. On information and belief, a targeted individual, TI, is someone who has been selected by Defendant Federal Bureau of Investigations, FBI, Defendant Department of Homeland Security, DHS, or other intelligence agencies of the federal government to unwillingly participate in an experimental torture program. On information and belief, this program was developed under the Central Intelligence Agency's MKUltra project and is designed to break down the individual and neutralize the person, using psychological, physical, and emotional stress. On information and belief, following Defendant FBI COINTELPRO model, this program imposes unconstitutional restrictions and limitations on society through intimidation, fear, and threats. Political activists, labor union leaders, scientists, and whistleblowers are a sampling of the main targets of the program in violation of their First Amendment rights. However, on information and belief, people are also randomly chosen. Familial and spousal relationships are usually destroyed, as part of this psychological torture. On information and belief, once an individual is on the list, the NSA unconstitutionally authorizes and/or carries out physical and electronic surveillance and stalking on them through various instrumentalities, organizations, and entities such as DHS National Network of Fusion Centers, InfraGard, citizen watch groups, sheriffs, and police departments. This conduct is referred to as organized stalking or gang stalking and entails the administration of terror tactics on United States citizens and lawful residents in violation of their rights under the 1st, 4th, 5th, 6th, and 14th Amendments of the United States Constitution. On October 3, 2012, the Senate's Permanent Subcommittee on Investigations issued a report after a 2-year investigation that led the commission to conclude that fusion centers have too often wasted money and stepped on Americans' civil liberties. 8. The report went on to conclude that defendant DHS intelligence officers assigned to state and local fusion centers produced intelligence of uneven quality, oftentimes shoddy, rarely timely, sometimes endangering citizens' civil liberties and Privacy Act protections, occasionally taken from already published public sources, and more often than not unrelated to terrorism. 8 https://www.hsgz.senate.gov/mo/media/doc/10-3-2012% sign 20 psi sign 20 staff sign 20 report sign 20 sign 20 fusion 20 centers. Point 2.pdf. The report went on to state that the panel includes several examples of costly and time-consuming investigations undertaken by fusion centers' employees, all which emphasize what appear to be the DHS relentless attempts to enter anyone and everyone into a system of suspicious persons. Emphasis hours. Defendants Mayorkas and Weinstein create and mandate the policies and standard operating procedures implemented in the National Fusion Center Network that carry out the unconstitutional organized stalking against plaintiffs, TJ members, and others equally situated to them. Plaintiffs' targeting resulting from their inclusion on the list. On information and belief, individual plaintiffs' names are listed under TSDB's NIS, handling code 3 or 4 or any other unknown category within the list that is not handling code 1, known terrorists/no-fly list, and handling code 2, selectee list. Defendants secretly added the individual plaintiffs' and TJ members' names to the TSDB without giving them prior notice. On information and belief, individual plaintiffs and TJ members were included in the TSDB in retaliation for exercising their First Amendment rights to practice their religion, exercising their freedom of speech, their right to peaceably assemble, and/or to petition the government for redress of grievances. The named individual plaintiffs and/or some of TJ members have submitted Privacy Act requests to defendants requesting them to provide the TSDB with their records and to remove their names from it. Defendants' failure to meaningfully reply and refusal to acknowledge their petition for removal from the TSDB prompted the filing of this complaint. Defendants' actions constitute a violation to plaintiffs' and TJ members' due process and equal protection rights under the 5th, 6th, and 14th Amendments of the United States Constitution inasmuch as they a. deprive them of their right to receive notice about their nomination to the TSDB, b. deprive them of a formal, open explanation of charges, and c. deprive them of a meaningful opportunity to challenge and disprove them prior to their inclusion on the list. Prior to including the named individual plaintiffs and TJ members, defendant FBI did not carry out a constitutionally mandated investigation observing its own procedures, nor did they oblige the minimum due process requirements and adhere to the standard of proof required for their inclusion. On information and belief, defendants included the named individual plaintiffs and TJ members' names to the TSDB without any of the required actual basis linking an individual to terrorism or terrorist activities, also known as particularized derogatory information. Defendants have failed to provide the named individual plaintiffs and TJ members included under the NIS or handling code 3/4 categories a legally meaningful procedure that adheres to the minimum constitutional due process requirements to challenge their inclusion on the TSDB. The only mechanism available to United States citizens and residents to challenge their inclusion in the TSDB contained in the Redress Standard Operating Procedure Manual is not available to NIS because the first requirement that gives way to the redress process is the completion of the DHS trip form documenting the details of the impaired travel plans as a result of the individual's inclusion in the TSDB. The TSC, which is administered by defendant FBI, does not accept redress inquiries from the public, nor does it directly provide final disposition letters to individuals who submit redress inquiries through defendant DHS or Congress. The TSDB regulations prohibit notice, access, and amendment under the Privacy Act. 70 Federal Register 43717 provides, in pertinent part, because this system contains classified and law enforcement information related to the government's counterterrorism, law enforcement, and intelligence programs, records in this system have been exempted from notification, access, and amendment to the extent permitted by subsections J and K of the Privacy Act. The Convention Against Torture defines torture as follows. The term torture means any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purposes as obtaining from him or a third person information or a confession, punishing him for an act he or a third person has committed or is suspected of having committed, or intimidating or coercing him or a third person, or for any reason based on discrimination of any kind, when such pain or suffering is inflicted by or at the instigation of or with the consent or acquiescence of a public official or other person acting in an official capacity. It does not include pain or suffering arising only from, inherent in, or incidental to lawful sanctions. By denying plaintiffs and TJ members an adequate process or mechanism to remove their names from the TSDB's NIS/handling code 3/4 categories, defendants Ray, Cable, Mayorkas, and Weinstein are personally liable to each individual plaintiff violating their constitutional rights protected under the 1st, 4th, 5th, 6th, 8th, and 14th Amendments. On information and belief, by denying TJ members residing in the United States and throughout the world a process or mechanism to remove their names from the TSDB's NIS/handling codes 3/4 categories despite the absence of particularized derogatory information and or a reasonable suspicion that they are KSTs, defendants Ray and Cable, have facilitated and enabled physical and psychological torture to plaintiffs in violation of the United Nations Convention Against Torture and other cruel, inhuman, or degrading treatment or punishment. TI's unconstitutional sentencing to a life of psychological and physical harm. The government does not provide a United States citizen or lawful resident with any meaningful opportunity to challenge or controvert the grounds for his or her possible inclusion on the TSDB. On information and belief, the inclusion of individual plaintiffs' names and that of TJ members on the TSDB causes them to suffer everything from cumulative inconveniences to serious reputational damage, threats to their lives, or substantial limitations on privacy and freedom of action, as will be set forth below. On information and belief, as a result of defendant FBI's unfounded and unconstitutional inclusion of innocent United States citizens such as the named individual plaintiffs and TJ members in the TSDB carried out under the direction of defendant Mayorkas through the National Network of Fusion Centers, they became targets of surveillance, stalking, and directed energy weapons attacks in violation of their fundamental constitutional rights. Directed energy weapons attacks/Havana syndrome. On information and belief, as a result of their unfounded and unconstitutional inclusion in the TSDB, the named individual plaintiffs and TJ members are victims of directed energy weapons (DEW) attacks and other unidentified remote weaponry and instruments of harm. On information and belief, the DEW attacks that the named individual plaintiffs and TJ members have suffered have caused them to develop or are in the way of developing the condition known as Havana syndrome. On information and belief, the use of other unidentified remote weaponry and instruments of harm have caused harm and or destroyed and or unlawfully taken property, health, and life. The Department of Defense's joint publication 3-13 Electronic Warfare defines directed energy, D, as an umbrella term covering technologies that produce a beam of concentrated electromagnetic energy or atomic or subatomic particles. Directed energy weapons, DEW, is a system using DE primarily as a direct means to disable, damage, or destroy adversary equipment, facilities, and personnel. DE warfare is military action involving the use of DE weapons, devices, and countermeasures to either cause direct damage or destruction of adversary equipment, facilities, and personnel, or to determine, exploit, reduce, or prevent hostile use of the electromagnetic spectrum, EMS, through damage, destruction, and disruption. 9. DE weapons include high-energy lasers, high-power radio frequency or microwave devices, and charged or neutral particle beam weapons. Microwaves and lasers are both part of the electromagnetic spectrum, which includes light energy and radio waves. The distinction between them is the wavelength/frequency of the energy. While they are both part of the electromagnetic spectrum, laser and microwave weapons operate very differently and have very different effects. The burns in some of the plaintiffs are caused by microwave weapons. Cellular towers and satellites have the energy capacity to fire DEW, approximately the same amount of energy required to run 3,000 homes. The required electric capacity of a microwave weapon far exceeds the electrical 9CHTTPS:/www.nationalacademy.org/news/2020/12/new-report-assesses-illnesses-among-us-government-personnel and their families at overseas embassies, national defense. Defense University, Prism, Volume 8, Number 3, 2019, Energy Available in Any Household. In 2020, the National Academy of Sciences, NAS, Engineering and Medicine, which was commissioned by the U.S. State Department to investigate the matter, issued a report stating that the attack from radio frequency waves or DEW should be the most plausible explanation for the Havana syndrome illness that U.S. State Department employees at the Cuban embassy began to experience. The NAS found that for the Cuban embassy employees, Havana syndrome began with the sudden onset of a loud noise, perceived to have directional features, and accompanied by pain in one or both ears or across a broad region of the head, and in some cases, a sensation of head pressure or vibration, dizziness, followed in some cases by tinnitus, visual problems, vertigo, and cognitive difficulties. CIA Director William Burns admitted that it is unlikely that Havana syndrome cases have been caused by the use of a secret weapon by a hostile state. Target program victims show Havana syndrome symptoms and impairment. Plaintiffs Deborah Mahanger, her daughter and plaintiff BR have been diagnosed with Havana syndrome. On January 20, 2022, the Central Intelligence Agency stated that the over 1,000 Havana syndrome cases were caused by DEW attacks on United States citizens stationed in foreign nations could not be traced to a foreign adversary. It concluded that there was no sustained global campaign by a hostile power like Russia or China harassing United States with an untraceable weapon. The DEW attacks on NIS, United States citizens who have been unconstitutionally included in TSDB's NIS/handling codes 3/4 lists have caused them to develop symptoms similar to Havana syndrome. Plaintiffs' DEW attacks on NIS result from their unconstitutional inclusion in TSDB's NIS/handling codes 3/4 lists produce painful physical assaults and burns that take weeks to heal and look like these, voice to skull. As a result of the inclusion in the TSDB's NIS/handling codes 3/4 lists, about 2/3 of the named individual plaintiffs and TJ members suffer from another kind of remote/directed energy attack known as pulse-modulated voice signature or microwave auditory effect, commonly known as voice to skull. This torture tactic is documented under United States Patent Office Patent 4,877,027 for hearing system dated June 6, 1988. No civilian has the equipment required to produce a microwave beam that carries a voice signal and produce voice-to-skull effect. This patent consists of a hearing system for human beings in which high-frequency electromagnetic energy is projected through the air in a microwave beam of an intensity less than 3.3 kilowatts per square centimeter to the head of a human being, and the electromagnetic energy is modulated to create signals that can be discerned by the human being regardless of the hearing ability of the person. This microwave auditory effect produces in most of the named individual plaintiffs and TJ members a torture known as voice-to-skull that mimics the hearing of voices or microwave auditory effect. V2K is an extremely debilitating condition as it operates 24 hours a day in a continuous flow of computer-generated derogatory verbiage to obliterate the person's psyche, such as, "You're stupid, you're fat, why don't you kill yourself?" Approximately 2/3 of plaintiffs and TJ members have the condition known as V2K. On information and belief, as a result of being included in the TSDB's NIS/handling code 3/4 lists, plaintiffs and TJ members suffer from sleep deprivation and the anxiety it produces caused by remote DEW attacks. On information and belief, as a result of their unfounded and unconstitutional inclusion in the TSDB's NIS/handling code 3/4 lists, plaintiffs and TJ members suffer from artificial tinnitus triggered by the constant location tracking inherent to the targeting program. No private organization has the capacity to inflict widespread V2K, DEW, or artificial tinnitus on the civilian population of the United States. Unconstitutional interference with electronic communications. As a result of their unfounded and unconstitutional inclusion in the TSDB's NIS/handling code 3/4 lists, plaintiffs, TJ members, and those similarly situated experience constant hacking of computers, emails, accounts, and interference with phone and electronic communications, constituting suspicionless seizure and searching of internet traffic on U.S. soil. In the course of this surveillance, United States communications are seized indiscriminately while they are in transit, in violation of Article 3 and the 1st, 4th, and 14th Amendments of the Constitution of the United States. The constant interference with electronic communications like the ones that plaintiffs and their counsel undergo constantly is similar to the situation currently the object of a judicial challenge in case Wikimedia Foundation v. NSA, number 1:15 CV 00662 TSE, DEMD, number 15 to 2560, 4th Circle. Petition for a writ of certiorari filed on August 26, 2022. Plaintiffs request that this court take judicial notice of this case. In 2019, the New York Times published an article confirming that in only 2 years, the TSDB had increased to 5.5 million records, of which 200,000 or 3.6% of them are United States citizens classified as targets, while the NSA acknowledged that during that same year it was spying on 200,000 targets on U.S. soil. 10. On October 21, 2021, the USDOJ Office of Inspector General released an Audit Report 11 denouncing defendant FBI's was widespread non-compliance with the factual accuracy review procedures, Woods procedures, required for applications under Section 702 of the Foreign Intelligence Surveillance Act, FISA, Section 702, 50 U.S.C. 1804, A4, and 50 U.S.C. 1801, H, to carry out electronic surveillance of U.S. persons. 12 Plaintiffs request that this court take judicial notice of this audit. Defendant FBI obtains FISA warrants for the covert collection of foreign intelligence information from foreign powers or agents of foreign powers suspected of espionage or terrorism. 13. FISA Court acknowledges it approves 99% of all wiretap applications. 1410 https://archive.ph/mobhb11 https://oig.justice.gov/site/default/files/reports/21-129.pdf 12 https://archive.ph/6bhao number sign selection -663.426-663.535 13 https://oig.justice.gov/site/default/files/reports/21-129.pdf 14 https://www.npr.org/sections/the 2-way/2013/2035/234840282/visa-court-we-approve-9-% of-wire-tap-applications. In November 2021, the presiding judge of the FISA Court, James Boasberg, issued a ruling concluding that defendant FBI has been seriously and systematically abusing its warrantless electronic surveillance authority. A prior 2019 audit report had revealed that defendant FBI had engaged in a pattern of abuses and deficiencies in the FBI's FISA process. 15. FISA orders can be used to surveil U.S. persons, and in some cases, the surveillance will foreseeably collect information about the individual's constitutionally protected activities. Traditional criminal search warrants that are granted in ex parte hearings but can potentially be subject to later court challenge, whereas FISA orders generally do not undergo scrutiny through subsequent adversarial proceedings. On information and belief, defendant FBI effortlessly obtains wiretap/surveillance warrants through the FISA court since the procedure does not require the probable cause standard that Article 3 courts demand in 18 U.S.C. 2518, 3a, applications. Unlike warrants granted under 18 U.S.C. 2518, 8d, where the government must inform the person object of the warrant that his or her communications were collected, FISA court-issued warrants don't require defendant FBI to ever notify the subject that his or her communications were collected unless government proceeding is brought against the person. As part of the 97% of individuals on the TSDBs grouped under the NIS/handling codes 3/for categories who have no ties to terrorism, plaintiffs have a right to know how many FISA warrants has the FBI obtained to listen into their conversations and communications. 15 https://www.foxnews.com/politics/jordan-biggs-fbi-answers-visa-violations-declassified-fisc-opinion. On information and belief, any FISA warrant for the surveillance, search and/or seizure of plaintiff's communications and/or property that defendant FBI obtained was done so in violation of law since the agency knows plaintiffs have no ties to terrorism. On information and belief, any sneak and peek warrant that defendant FBI has obtained and executed against plaintiffs and TJ members under Section 213 of the Patriot Act is in violation of law since its agents know that plaintiffs have no ties to terrorism. Just as the illegal actions denounced in the Wikimedia case, on information and belief defendant FBI has relied on the Foreign Intelligence Surveillance Act, FISA, 50 U.S.C. Section 1801, to carry out illegal surveillance on plaintiffs, TJ members and other equally situated NIS electronic communications. Under Section 702 of FISA, 50 U.S.C. Section 1881A, defendant FBI can apply for the interception and upstream surveillance of plaintiffs and TJ members' electronic communications without the need for any court to review or approve the individual targets of the surveillance based on their secret, unconstitutional inclusion in the TSDB's NIS/handling code 3/for categories. On information and belief, 4 years and devoid of probable cause that meets the Fourth Amendment's mandates, defendant FBI has illegally intercepted, recorded, listened in, stolen electronic communications and files from plaintiffs and TJ members under the pretext that their names appear in the TSDB. On information and belief, all warrants obtained and carried out against plaintiffs and TJ members' electronic surveillance and secret searches and seizures are contrary to law and in open violation of their privacy rights. Defendants FBI and DHS are jointly liable for the damages the execution of any such illicit warrant caused plaintiffs. National Fusion Centers organized stalking of TSDB-listed individuals. The National Network of Fusion Centers, is under the purview of the DHS as a mechanism for counteracting terrorism. Although the Fusion Centers are deemed state-owned and operated, defendant FBI and defendant DHS employees are assigned to work in them. The Fusion Centers network have become the Stasi arm of defendant DHS. They conduct surveillance, stalking, cyberstalking, and other clandestine and illegal operations against everyone in the TSDB, from KST to NIS. Defendant DHS controls and funds 100% of the Fusion Center network operations. Defendants Mayorkas and Weinstein are responsible for the determinations regarding funding, creation and implementation of the policies, standard operating procedures and tactics implemented at the Fusion Centers throughout the nation. Defendant FBI employees under the supervision and control of Defendant Ray and/or Cable directly work at Defendant DHS Regional Fusion Center Network to implement and witness the unconstitutional, rogue and illegal organized stalking carried out against people listed in the TSDB. Defendant DHS Fusion Centers personnel and contractors have carried out illegal surveillance, search and seizures and organized stalking of plaintiffs and TJ members due to their inclusion on the TSDB's NIS/handling codes 3/for category in violation of their Fourth Amendment rights. DHS Fusion Centers personnel and contractors have inflicted psychological torture on plaintiffs and TJ members in violation of their constitutional right to be secure in their persons, houses, papers, and effects and against unreasonable searches and seizures enshrined in the Fourth Amendment of the United States Constitution. Defendants Mayorkas and Weinstein create and mandate the unconstitutional policies and standard operating procedures that the fusion centers implement to carry out plaintiffs and TJ members' organized stalking. As such, they are personally liable for the illegal stalking and torture of the named individual plaintiffs and TJ members included in the TSDB's NIS/handling codes 3/4 lists, in violation of the Fourth Amendment that protects persons and their things from illegal searches and seizures, the Fifth and Sixth Amendments that prohibits the imposition of a sentence on a person without due process of law, the Eighth Amendment that prohibits the infliction of cruel and unusual punishments, and the 14th Amendment that guarantees the equal protection under the law. As a result of defendant FBI's unfounded and unconstitutional inclusion in the TSDB as part of a largely secret, covert program, United States citizens and residents such as the named individual plaintiffs and TJ members suffer stigmatic government action. As a result of being unfounded and unconstitutionally included in the TSDB's NIS/handling codes 3/4 lists, plaintiffs and TJ members experience constant harassment known as gang stalking, organized stalking, or overt harassment, OH, that includes the use of organized stalkers to carry out the vandalizing of personal property, surreptitious entries into domicile, tampering with postal mail, computer, and telephone, spreading false and defamatory rumors about the individual in the neighborhood and workplace to attain their virtual ostracizing from society. The illegal and unconstitutional organized/gang stalking that fusion centers carry out against plaintiffs and TJ members occurs pursuant to defendant Mayorkas and Weinstein's orders, authorization, and/or supervision. These psychological operations follow the FBI manual crafted for the program's predecessor, COINTELPRO. The guiding policy of the program is that the illegal actions they carry out against the target be plausibly deniable. When complaining to law enforcement agencies or physicians about the events and symptoms resulting their status as a TI, some of the individual plaintiffs and most of TJ members have been illegally detained for mental health observation and deprivation of their liberty without due process, in violation of their rights under the 5th, 6th, and 14th Amendments of the United States Constitution. As an example of the above, last year, Plaintiff Hobson called defendant FBI's offices to denounce the gang stalking and DEW attacks she was suffering from. The first dispatcher hung up on her when she reported the crimes of gang stalking and DEW attacks. Upon calling a second time, a different dispatcher also dismissed her, told her she needed to take her medication and said, "You people are all crazy." At this juncture, Plaintiff Hobson asked the dispatcher if she received any such calls frequently. She replied, "All the time." Prior to being included in the TSDB, none of the individually named plaintiffs or TJ members experienced any of the events described above unless they were victims of the MKUltra or COINTELPRO programs. On information and belief, an estimated 200,000 individuals in the United States included in the TSDB's handling codes 3/4 categories every day undergo various forms of torture including DEW attacks, V2K, and organized stalking in violation of the Convention Against Torture ratified by the United States of America in 1994. All of it paid for with taxpayers' money. An illegal targeting program based on sex discrimination. Title VI of the Civil Rights Act provides that a law enforcement agency must make sure that its policies and practices do not have the effect of discriminating against people because of their race, color, or national origin. This provision is extensive to federal officials under the Bivens Action Mechanism. The Department of Justice's most recent available national crime statistics, 2020, reflect that an average of 73.48% of crimes are committed by men and 26.52% by women. Gender percent of all offenses, all ages 0 to 25 and older males 73.48%, 5,608,600, 1,383,464, 1,225,140 females 26.52%, 2,023,870, 527,810, 1,496,050. Conversely, on information and belief and based on TJ's data on the TI community, 66.6% of TIs are women. On information and belief, there is an inverse correlation in terms of gender between the actual crime perpetrators, a majority of men, and the people listed as NIS in the TSDB, a majority of women. On information and belief, defendants apply the TSDB against women in a manner that is different from how they use it against men. TJ's data demonstrates that the illegal targeted individual program discriminates against single women who compose 66.6% of the TI community. This pattern demonstrates that the targeted individual program also constitutes a hate crime against women. Aside from creating, enabling, and/or maintaining an unconstitutional, illegal, and criminal torture program, defendants Christopher Ray, Charles Cable Jr., Alejandro Mayorkas, and Kenneth Weinstein are personally liable under Bivens for implementing regulations and policies that have resulted in the illegal discrimination against women that predominantly occupy the ranks of targeted United States citizens and lawful residents within the TSDB's NIS/handling code 3/4 categories. An illegal.
Now, I want to stop here because I want to show you guys something, okay? So let's go to the home page here. And here it talked about, so they're filing this lawsuit and they're suing for $1.3 billion. Okay, $1.3 billion. Now, this number, it's huge, okay? And when it comes to the amount, a plaintiff can put whatever amount they want. Obviously, it has to be justifiable based on damages and shown proof that of health issue or permanently something permanent, okay, in damages. So it has to be justifiable to add up to $1.3 billion. But that number can be anything. And right here on this preliminary injunction filed 5th of February. So this is the most early document. I'm gonna open it. So this looks a lot more official than the text, copy paste text from that we've been listening to. And this is early too. This is the most recent. So I'm gonna go find the word mercy. Oh, it's not there. Okay, hold on. It was. There's a part here that talked about having the evidence. Oh, here we go. Look. Right here. Perhaps the single most important prerequisite for the issuance of a preliminary injunction is a demonstration that if it is not granted, the applicant. Oh, sorry, this is not the part. Currently, defendant control most of the evidence that plaintiffs need to prove the organized stalking that results from being included on the McCarthy blacklist of the TSDB. When the facts about causation may be in the control of the punitive defendant, then the plaintiff is more at the mercy of the defendant. So this basically says it all. They don't have the evidence. And the defendant are the ones with the evidence. So they don't have the evidence, the official forms showing the name of the plaintiffs and in connection with the defendant, usually by a signature, to prove that the claims that the plaintiffs are making are true. So they're missing that document. And they're saying that the defendants are the one with the document, and they will request it during the discovery phase of this lawsuit, and the defendants will not provide that. So without that document, all this, everything else, it's possible, but have nothing to do with the plaintiffs. Because the plaintiffs are the ones suing for $1.3 billion. And to get that amount, or even get 1 million of that 1.3 billion, there needs to be solid proof beyond reasonable doubt that the plaintiffs are being tortured in this program, and that needs to show the plaintiff's name on an official document. and they don't have it. You might think I'm just trying to bash on this lawsuit. I'm not. I'm just stating facts. I'm not going to tell you, oh yeah, go ahead and do it. Yeah, you got it. If you got it, I will tell you, you got it. You need to file a lawsuit. I will tell you that straight up. When you don't got it, in the case of this plaintiffs, I'm not going to be saying, oh yeah, this will be good. Just go do it. But then I also know in the TI's mind, once that idea is in the TI's mind, the TI will have to get the answer. So the TI will have to do it just to know. So I'm okay with that. But I'm just saying, the ones that are going to be winning out of this lawsuit are the attorneys. They're going to get paid regardless. Well, that's if the attorney representing the plaintiffs if she is doing it for free, pro bono. She only gets paid once they win, and the defendants will have to pay for that. But the defendant will also come back with, if the defendant wins the case, then the defendant's attorney is going to make the plaintiffs pay for their attorney's fee. Or they could just not go to the judge and just settle, just straight up just settle it before the judge, before a jury. But the defendant is not going to pay a dime. So I don't know how they're going to settle this without seeing a judge. Or maybe the defendants just don't want trouble and they just want to just pay for their own attorney's fees and just settle it. But why would the defendant do that? Because later on, they could get sued again. So if the defendant know that they're going to win, they can also ask the judge to have the plaintiff to never ever bring this up again and pay for the attorney's fees. So those are facts. I'm just stating facts. I'm not trying to talk down on the lawsuit. But that's just how, in general, that's how the court system works. So I'm going to go back to this part.
Illegal targeting program that preys on the disenfranchised. On information and belief, as a result of being included in the TSDB's NIS/handling code 3/4 lists, plaintiffs and TJ members have been blacklisted from employment, their professions and communities. TJ statistics obtained within its membership reflect the following. 14% are homeless, national average is 0.5%. 35% are living with a relative or friend because they cannot afford to pay rent. 67% are unemployed, national average is 3.7%. 40% were indigent, having less than $100 in their possession, substantially below the poverty line. On information and belief, when exposing the abuses and deprivations delineated herein, plaintiffs and TJ members have been deprived of their constitutional rights without due process of law or assistance of counsel. Under the direction and authority of Mayorkas, Weinstein and their predecessors, state, tribal, and federal law enforcement have enabled and facilitated the incarceration and/or hospitalization of some plaintiffs, TJ members, and other individuals equally situated to them. Claims for relief. Claims common to all plaintiffs. The foregoing allegations are re-alleged and incorporated herein. Plaintiffs and TJ members' inclusion in the TSDB violates the First Amendment. Plaintiffs and TJ members' inclusion in the TSDB and the consequences thereof violate the Fourth Amendment's prohibition against illegal searches and seizures. Plaintiffs and TJ members' inclusion in the TSDB and the consequences thereof violate their substantive and procedural due process rights contained in the Fifth, Sixth, and 14th Amendments by depriving them of their property and freedom without due process of law. Plaintiffs and TJ members' inclusion in the TSDB and the consequences thereof violate the accepted values of human dignity, civilized society, and human decency embodied in the Eighth Amendment prohibition against cruel and unusual punishment. Plaintiffs and TJ members' inclusion in the TSDB and the consequences thereof violate their fundamental rights to privacy embodied in the 4th and 14th Amendment. First cause of action, writ of mandamus. The foregoing allegations are re-alleged and incorporated herein. Defendants' actions violate the President's constitutional duty that his cabinet members are compelled to follow. To wit, that of TAC, ing, care that the laws be faithfully executed. U.S. Constable Art. 2, Section 3. Plaintiffs request that this court direct the defendants to purge their names as well as those in TJ members from its TSDB's NIS/handling code 3/4 categories. Plaintiffs request that this court enter judgment as follows. Finding that defendants' joint illegal interpretation, handling and execution of their ministerial duties as they pertain to the TSDB's NIS/handling code 3/4 lists have resulted in the unconstitutional deprivation of plaintiffs' TJ members' liberty and property interests without due process of law in violation of the 5th, 6th, and 14th Amendments of the United States Constitution through their secret nomination process, inclusion and maintenance thereto despite lack of particularized derogatory information tending to demonstrate they are a KST. Finding that defendants engaged unconstitutional enabling and implementation of an illegal targeting and surveillance program that preys on, tortures and results in the deaths of United States citizens and lawful residents in violation of the constitutionally protected rights delineated herein. Plaintiffs request that the court order defendants Ray and Cable to adhere to constitutional and human rights precepts inherent to their position and which they vowed to adhere to, and bring to an end the unconstitutional enabling and implementation of an illegal targeting program based on age and sex discrimination targeting of middle-aged women. Holding defendants jointly liable for the enabling and implementing of an ongoing crime against humanity of a highly illegal targeting program that preys on, tortures and prompts the death of innocent civilians throughout the world included under TSDB's NIS/handling code 3/4 categories and the consequences thereof, in violation of the United Nations Convention 1753 against torture and other cruel, inhuman or degrading treatment or punishment, ratified by the United States of America in 1994. Ordering defendants to immediately remove plaintiffs' and TJ members' names from the TSDB and recall all versions that contain their names and have been disseminated among federal, local, tribal, and foreign governments, private entities, and persons. Awarding plaintiffs' counsel fees and costs pursuant to the All Writs and Declaratory Judgment Act. Second cause of action, Administrative Procedures Act. The foregoing allegations are re-alleged and incorporated herein. Plaintiffs and TJ members have suffered harm as a result of defendant FBI's act of including them in the TSDB. Plaintiffs and TJ members have been adversely impacted and aggrieved by FBI's agency action of including them in the TSDB that resulted in the detrimental social, psychological, and physical consequences attendant thereto and resulting therefrom. By denying plaintiffs and TJ members' request for disclosure of their inclusion in the TSDB, defendants FBI and DHS divest plaintiffs and TJ members of their constitutionally protected right to petition a court of competent jurisdiction for relief. Defendant FBI and defendant DHS actions violate Sections 702 and 706 of the APA, 5 U.S.C. Sections 702, 706, by creating, promulgating, implementing, and relying upon the TSDB in open violation of plaintiffs and TJ members' 5th and 6th Amendment rights to due process of law. Defendants' violations under APA are continuous and uninterrupted to the extent that innocent United States citizens and residents continue to be included in the TSDB without legal grounds therefor. Third cause of action, declaratory judgment under the Administrative Procedures Act, the Privacy Act, and the Constitution of the United States. The foregoing allegations are re-alleged and incorporated herein. The United States District Court has jurisdiction to adjudicate this petition to enter declaratory judgment holding the NIS subcategory of the TSDB as well as the TSDB nominating and inclusion procedures in it as unconstitutional on the grounds set forth below. Defendants have violated the APA by promulgating, implementing, relying upon and circulating the TSDB's NIS/handling code 3/4 lists to government and non-government entities and persons in violation of the Privacy Act, 5 U.S.C. Section 502(a), causing substantial and irreparable damages to the named plaintiffs and TJ's members. The handling codes 3/4 or non-investigative subjects parts of the TSDB constitute an unconstitutional blacklisting of American citizens and residents by including people who are not known or suspected terrorists, which in turn negatively and indefinitely impacts their lives. The standards for inclusion in the TSDB's NIS/handling codes 3/4 lists are overly broad and vague, and the information they rely on is not accurate or credible. The manner in which the NIS subcategory in it is used is not consistent with the presumption of innocence and the right to a hearing before punishment. The availability of the blacklisting of people through the TSDB by private nominating persons and corporations allows for its abuse for personal or commercial revenge purposes in violation of individuals' constitutionally protected rights. The persistent and permanent languishing of individuals on the TSDB's NIS/handling codes 3/4 subcategories, despite the lack of particularized derogatory information tying them to acts of terrorism and/or a reasonable suspicion that they are a known or suspected terrorist, KST, constitutes an unconstitutional deprivation of their property and liberty rights, destroying their lives. The absence of notice prior to inclusion and/or a viable mechanism to discover one's inclusion on the TSDB, correct errors, and obtain removal after being included on it for improper or illegal purposes is a violation of plaintiffs' rights to substantive and procedural due process. There is no notice nor meaningful way to contest a person's designation as a potential terrorist and ensure that the United States government, and all other users of the information, removes or corrects inaccurate records. Discrimination as an unconstitutional motive. The TSDB's NIS/handling codes 3/4 subcategories demonstrate defendants' illicit motives behind the nomination and inclusion of individuals in it. Beyond the illegal motive of human experimentation lies the sex discrimination that the disproportionate amount of women in the experiment reflect. Even though national crime statistics reflect that an average of 82% of crimes are carried out by men, an average of 66.6% of TIs are single women. On information and belief, this inverse correlation demonstrates that the target program constitutes a massive hate crime against women in violation of the Conspiracy Against Rights, 18 U.S.C. Section 241, and the Matthew Shepard and James Byrd Jr. Hate Crimes Prevention Act of 2009, 18 U.S.C. Section 249. Discrimination in violation of the First Amendment. Inclusion on the TSDB's NIS/handling codes 3/4 subcategories on information and belief is based on unconstitutional discrimination for political beliefs and affiliation. On information and belief, victims of the illegal torture under the targeted individual program are chosen in violation of the First Amendment as TJ's membership disproportionately identifies with conservative/Republican beliefs. TJ surveys reflect the following. TJ members are 5.8 times more likely to be Republican than Democrat. 52% of TJ members vote Republican. 9% of TJ members vote Democrat. 17% will not vote/are fed up with the system. 22% are undecided/independent voters. Discrimination on economic grounds. Inclusion on the TSDB's NIS/handling codes 3/4 subcategories on information and belief promotes the economic disparity that is destabilizing to the country. The theft and vandalism inherent to the program drain the scant financial resources most TIs have been left with. Plaintiffs, TJ members, and others situated like them find themselves constantly having to spend their savings or limited income in fixing or purchasing basic necessary items and objects to replace stolen or broken ones. On information and belief, the majority of TIs are mostly low income and disadvantaged because the program/apparatus is designed to push them into a downward economic spiral by interfering with their employment opportunities and depriving them of their property rights without just compensation or due process of law. Unreliability of the TSDB NIS/handling code 3/4 data. TSDB records are not appropriately generated, updated, or removed as required by the Constitution. The absence of a viable mechanism to discover a person's inclusion on the TSDB's NIS/handling codes 3 to 4 categories, correct errors, and remove his or her name after being included in it for improper or illegal purposes is a violation of due process. There must be a meaningful way to contest a person's designation as a potential terrorist and ensure that the U.S. government, and all other users of the information, removes or corrects inaccurate records. As implemented, the government's TSDB's NIS/handling codes 3/4 categories amount to an unchecked, illegal and unconstitutional exercise of power over American citizens and residents. The availability of the blacklisting mechanism provided by the TSDB's NIS/handling codes 3 to 4 categories by private nominating persons and corporations allows for its abuse for personal or commercial revenge purposes and violates individuals' constitutionally protected property, due process, and liberty rights. For all the reasons stated herein, plaintiffs request that this court enter declaratory judgment declaring the TSDB's NIS/handling codes 3 to 4 categories and the human experimentation program on targeted individuals stemming from it repugnant to the United States Constitution as it violates the following: First, Fourth, Fifth, Sixth Amendments of the Constitution of the United States by punishing its victims for the exercise of free speech, conducting illegal searches and seizures of their person and things, and depriving them of property and liberty without due process. Eighth Amendment as it constitutes totalitarian, cruel, and unusual punishment. 14th Amendment as the experimentation program disproportionately targets women and conservatives, and the United Nations Convention 1753 against torture and other cruel, inhuman or degrading treatment or punishment, ratified by the United States of America in 1994. Plaintiffs are entitled to the recovery of attorney's fees and costs under 5 U.S.C. 552, Fourth cause of ACTION permanent injunction. The foregoing allegations are re-alleged and incorporated herein. Plaintiffs, TJ members, and the individuals similarly situated are in immediate danger of sustaining direct and serious injuries as the result of the official conduct denounced in this complaint. Plaintiffs request that this court issue a permanent injunction ordering defendants to immediately eliminate plaintiffs and TJ members' names from the TSDB's NIS/handling codes 3 to 4 categories and ban defendants from including them in any other secret catalog, list or index or circumvent the court's order in any way. Recall and recover the over 18,000 disseminations of these catalogs, lists or indexes to law enforcement, private companies, individuals and entities that contained plaintiffs' names and personal identifiers. Prohibit defendants devising, perpetrating, and enabling the surveillance, organized stalking and psychological torture against plaintiffs and TJ members through DHS fusion centers, contractors such as InfraGard, CitizenCorps, and or any other person or entity defendants concoct, collude with or hire for those purposes. Permanently enjoin defendants from continuing making fraudulent visa applications and or carry out warrantless surveillance of their personal belongings and electronic communications devoid of probable cause as required by the Fourth Amendment. Permanently enjoin defendants from creating another experimentation program or list to include plaintiffs or TJ members listed on the TSDB's NIS/handling codes 3/4 categories. Order defendant FBI to immediately produce the entire NIS/handling code 3/handling code 3 sublists of the TSDB and grant plaintiffs and TJ members the right to examine when and why they were included in the TSDB. Hold defendants jointly liable for plaintiffs' damages and order them to pay them the amounts alleged for each one as specified in the paragraphs above incorporated herein. Compel the defendants to fund the creation of a court monitoring system to ensure full compliance with the court's orders regarding the elimination of any list within the TSDB that contains individuals not meeting the reasonable suspicion standard and to ensure that there shall exist no illegal human experimentation program such as the Targeted Individuals Program persists. Fifth cause of ACTION Privacy Act violations. The foregoing allegations are re-alleged and incorporated herein. Under Freedom of Information/Privacy Acts, Defendant FBI and Defendant DHS has 20 working days to respond to a request. 5 U.S.C. Section 552(a)(6)(a)(I). If there are unusual circumstances, an agency may extend the time limit by no more than 10 working days. ID Section 552(a)(6)(b)(I). More than 30 days have passed since most plaintiffs filed the request. Thus, these statutory time periods have elapsed. The urgency of the injunction requires us to move forward. To date, neither Defendant FBI nor Defendant DHS have released responsive records to plaintiffs' requests, nor have they justified their failure to do so. Defendant FBI and Defendant DHS continue to wrongfully withhold the requested records from plaintiffs. Defendant's failure to make a reasonable effort to search for records responsive to the request violates the FOIA, 5 U.S.C. Section 552(a)(3), and their corresponding regulations. Defendant's failure to promptly make available the records sought by the request violates the FOIA, 5 U.S.C. Section 552(a)(3)(a)(6)(a), and defendant's corresponding regulations. Defendant's failure to process plaintiff's request expeditiously and as soon as practicable violates the FOIA, 5 U.S.C. Section 552(a)(6)(e), and their corresponding regulations. Defendants FBI and DHS are liable to plaintiffs for counsel fees and costs incurred in the filing of this claim pursuant to 5 U.S.C. Section 552(a)(4)(e)(i). Sixth cause of action, plaintiff's individual damages. The foregoing allegations are re-alleged and incorporated herein. Defendants Ray, Cable Jr., Mayorkas and Weinstein are jointly liable to plaintiffs in their personal capacity for the damages set forth below resulting from their reckless deprivation of plaintiffs' civil and human rights. Defendants are federal public officials acting under color of federal authority that have disregarded their duty to adhere to the laws and Constitution, depriving the individual plaintiffs of their civil rights. As such, they are liable to plaintiffs under Bivens v. 6 Unknown Named Agents of Federal Bureau of Narcotics, 403 U.S. 388, 1971, and plaintiffs' civil rights for violating their rights under the 1st, 4th, 5th, 6th, 8th, and 14th Amendments of the United States Constitution as well as the Convention Against Torture. Defendants Ray, Cable Jr., Mayorkas and Weinstein are jointly and severally liable in their personal capacities for the entire amount of damages alleged herein, regardless of whether the conduct of one directly caused more or less injury compared to that of another, because they a. have acted together with a common purpose resulting in responsibility for the common injury by including plaintiffs' names in the TSDB's NIS/handling codes 3/for categories even though they are not associated to acts of terrorism, b. they have intentionally disregarded plaintiffs' constitutional, civil and human rights, and c. they have perpetrated in an uninterrupted manner the conduct and illicit acts of their predecessors. The injury or threat of injury to plaintiffs is actual, concrete, extraordinary, and particularized. Inasmuch as the continuous and uninterrupted targeting damages directly correlate with defendants' decision to keep plaintiffs listed in the TSDB's NIS/handling codes 3/for categories, the former are also jointly liable for the real and immediate damages resulting from DEW attacks alleged herein. Plaintiff Leonid B.R. The foregoing allegations are re-alleged and incorporated herein. Plaintiff Leonid B.R. came to the United States in 2003 from the former Soviet Union. He's a naturalized citizen of the United States. On or around 2019, Plaintiff B.R. realized he was a TI when he began having symptoms of V2K and DEW attacks. Defendant FBI's TSC nominated and included Plaintiff B.R. in the TSDB devoid of supporting particularized derogatory information linking him to terrorism. Plaintiff B.R. was nominated and included in the TSDB devoid of supporting particularized derogatory information about him, without being given notice or an opportunity to rebut his nomination. Defendant FBI failed to corroborate that Plaintiff B.R. was not associated to terrorist activity prior to including him in the TSDB as NIS/handling code 3/4 lists. Defendant FBI does not possess and has never corroborated having any particularized derogatory information linking Plaintiff B.R. to any act of terrorism. Plaintiff B.R. has never been convicted of any crime. Defendant FBI and Defendant DHS replied to Plaintiff B.R.'s Privacy Act requests but rendered no information on his inclusion in the TSDB. The only document produced was a copy of a complaint Plaintiff B.R. had himself electronically filed to denounce the DEW attacks that he sustained. Plaintiff B.R.'s inclusion in the TSDB has subjected him to defendant's physical and electronic surveillance and organized stalking in violation of his rights under the 1st, 4th, 5th, 6th, and 14th Amendments of the United States Constitution and the Convention Against Torture. Plaintiff B.R. sought the assistance of his congressional district representative, Senator Tammy Duckworth, to investigate the DEW attacks perpetrated against him. In reply to the inquiry Senator Duckworth made to the FBI regarding the DEW attacks that Plaintiff BR is a victim of, Defendant FBI on January 21, 2021 responded that the agency could not investigate without specific facts that indicate that a violation of federal law within our investigative jurisdiction has occurred. See Exhibit 6. Defendant FBI did not comply with its statutory obligation to investigate Plaintiff BR's claims that tend to demonstrate prima facie violations to the Convention Against Torture occurring within U.S. soil. Defendant FBI's dereliction of duty by refusing to investigate and prosecute the perpetrators of DEW attacks occurring on American soil increases Plaintiff BR's damages as the attacks on him remain unrestricted. Since 2019, Plaintiff BR has experienced constant disabling V2K symptoms attacks that have severely interfered with his daily life, personal interactions, capacity to work and live in peace. He estimates the damages he has suffered as a result of V2K in an amount exceeding $50 million. $50 million. As a result of Plaintiff BR's inclusion in the TSDB, he has undergone painful and disabling DEW on a daily basis to various parts of his body, inflicting on him severe and debilitating sleep deprivation, anxiety, permanent damage, and physical and mental pain and suffering. During the 5 years that Plaintiff BR has suffered constant DEW attacks perpetrated from satellites and cell towers, he estimates having suffered physical and mental pain and suffering valued in $15 million. $15 million. As a direct consequence of the DEW attacks Plaintiff BR has sustained and continues to undergo on a daily basis, he has been diagnosed with permanent brain injuries and Havana syndrome. The permanent physical damages and mental pain and suffering that the Havana syndrome condition causes him are estimated in an amount no less than $50 million. $50 million. Plaintiff BR's inclusion in the TSDB has subjected him to defendants' physical and electronic surveillance and organized stalking in violation of his rights under the 1st, 4th, 5th, 6th, 8th, and 14th Amendments of the United States Constitution and the Convention Against Torture, resulting in egregious mental anguish, anxiety, and suffering estimated in an amount no less than $10 million. $10 million. Plaintiff BR asks that this court hold defendants Ray, Cable Jr., Mayorkas and Weinstein jointly liable for his damages totaling $125 million, $125 million, and in light of their intentional, wanton, and willful misconduct in the deprivation of plaintiff's civil rights, impose on them the payment of punitive damages calculated at $375 million. $375 million. Plaintiff BR requests that Defendant FBI and Defendant DHS be held jointly liable for the negative social, professional and personal repercussions he sustained as a result of their illegal disclosure of his inclusion in the TSDB in violation of the Privacy Act and the suffering, anxiety, and loss this has caused him. These damages are estimated in minimum amount of $1 million per year, depending on the quality and quantity of the derogatory information shared outside of the agencies and the prejudice they caused. Plaintiff BR specifically requests that this court order defendants to remove his name from the TSDB's NIS/handling codes 3/ for categories, recall all lists containing his name, and instruct them to abstain from including his name in any other illegal database used to carry out human torture, experimentation, and/or any other improper purpose. Plaintiff BR requests that the court hold all defendants to be jointly liable for the payment of reasonable attorney's fees and costs under 28 U.S.C. Section 2412, 5 U.S.C. Section 552, A, 4, E, I, and Bibbins. Plaintiff Timothy Shelley. The foregoing allegations are re-alleged and incorporated herein. Plaintiff Shelley is a lawyer in good standing in the state of Delaware and the District of Columbia. On or around 2016, Plaintiff Shelley realized he had become a targeted individual. In hindsight, he believes he has been a target for decades. Plaintiff Shelley was nominated and included in the TSDB devoid of supporting particularized derogatory information linking him to terrorist activity, without being given any notice or opportunity to rebut, and based on his First Amendment protected activities. Defendant FBI's and Defendant DHS reply to Plaintiff Shelley's Privacy Act requests provided no information about his inclusion in the TSDB. Plaintiff Shelley's inclusion in the TSDB resulted in illegal break-ins to his home, physical and electronic surveillance, and organized stalking. For over 2 decades, he has undergone a plethora of abuses that include drugging, kidnapping, sexual battery, false imprisonment, job blocking, petty theft, and minor cyber attacks. In violation of his rights under the 1st, 4th, 5th, 6th, 8th, and 14th Amendments of the United States Constitution and the Convention Against Torture. The damages he has suffered as a result of the organized stalking exceed $54 million. $54 million. On or around September 2016, Plaintiff Shelley began hearing constant voice-to-skull, V2K, and showed symptoms of forced speech, severely impairing his daily activities and producing significant mental pain and suffering. He estimates these damages in $70 million. $70 million. On or around September 2016, Plaintiff Shelley began suffering from painful and disabling directed energy weapons, DEW, on a daily basis to various parts of his body, including the microwaving of genitals and lower digestive tract. These physical torture and damages are estimated in an amount no less than $21 million. $21 million. The constant DEW attacks perpetrated against him since 2016 have caused Plaintiff Shelley permanent brain and physical injuries estimated at $20 million. $20 million. Plaintiff Shelley requests that this court hold defendants Ray, Cable, Mayorkas and Weinstein jointly liable for his damages exceeding $165 million. $165 million. Given the malicious intent behind his targeting, experimentation, torture and suffering, Plaintiff Shelley also demands that the court hold defendants Ray, Cable Jr., Mayorkas and Weinstein jointly liable in the payment of punitive damages in an amount no less than $495 million. $495 million. Plaintiff Shelley requests that FBI and DHS be ordered to pay him damages for the illegal disclosure of his inclusion in the TSDB in violation of the Privacy Act, with the social, professional and personal repercussions, suffering, anxiety, and loss that this has caused him. These damages are estimated in minimum amount of $1 million per year, depending on the quality and quantity of the derogatory information shared outside of the agency and to be calculated when defendants provide the evidence of the extent of the disclosure. Plaintiff Shelley requests that the court impose on defendants joint liability in the payment of reasonable attorney's fees and costs under 28 U.S.C. Section 2412, 5 U.S.C. Section 552, A, 4, E, I, and Bivens. Plaintiff Shelley specifically requests that this court order defendants to remove his name from the TSDB's NIS/handling codes 3/4 categories, recall all lists containing his name, and instruct them to abstain from including his name in any other illegal database used to carry out human torture, experimentation, and/or any other improper purpose. Plaintiff Karen Stewart. The foregoing allegations are re-alleged and incorporated herein. Plaintiff Stewart was nominated and included in the TSDB in revenge for being a whistleblower at the National Security Agency. Her nomination was entirely devoid of supporting particularized derogatory information linking her to terrorist activity. Defendant FBI did not give her any notice or opportunity to rebut her nomination. Defendant FBI and Defendant DHS reply to the Privacy Act requests that Plaintiff Stewart sent each agency in December 2022 and January 2023. The agency's replies did not provide any of the information requested regarding her inclusion in the TSDB. On or around 2005, Plaintiff Stewart began to experience threats, defamation, stalking, and harassment. An acquaintance working for law enforcement personally confirmed to her that since her name appeared on the TSDB, he could not associate with her. In 2006, Plaintiff Stewart started experiencing break-ins, thefts, wiretap of home and phones. When she moved to Florida in 2014, she continued to be heavily stalked and harassed by neighbors. Since its inception, the organized stalking perpetrated against Plaintiff Stewart has not stopped. Part of the organized stalking Plaintiff Stewart has had to undergo is the forced hospitalization for mental evaluation and attempts at criminal entrapment. Plaintiff Stewart's inclusion in the TSDB prompted illegal break-ins to her home, vandalizing of her property, physical and electronic surveillance, and organized stalking for over 2 decades in violation of her rights under the 1st, 4th, 5th, 6th, 8th, and 14th Amendments of the United States Constitution and the Convention Against Torture. Plaintiff Stewart estimates her damages from organized stalking since 2005 in an amount no less than $18 million. $18 million. On or around 2016, Plaintiff Stewart began suffering from constant, painful, and disabling directed energy weapons (DEW) attacks on a daily basis to various parts of her body that caused her severe pain and burns. The physical torture and damages she has suffered as a result of DEW attacks are estimated in an amount no less than $21 million. $21 million. The constant DEW attacks perpetrated against Plaintiff Stewart since 2016 have caused her permanent brain and physical injuries as she has developed symptoms similar to those associated to Havana syndrome. She estimates these debilitating and permanent damages in excess of $20 million. $20 million. Plaintiff Stewart requests that this court hold defendants Ray, Cable, Mayorkas, and Weinstein jointly and severally liable for her damages estimated in $59 million. $59 million. Plaintiff Stewart requests that in light of the malicious intent behind her targeting, experimentation, torture, and suffering, the court hold defendants Ray, Cable Jr., Mayorkas, and Weinstein jointly liable to her for punitive damages for the amount of $177 million. $177 million. Plaintiff Stewart also requests that defendant FBI and defendant DHS be ordered to pay her damages for the illegal disclosure of her inclusion in the TSDB, with the social, professional, and personal repercussions, suffering, anxiety, and loss that this has caused her. These damages are estimated in minimum amount of $1 million per year, depending on the quality and quantity of the derogatory information about Plaintiff Stewart shared outside of the agency, to be calculated when defendants provide the evidence of the extent of the disclosure. Plaintiff Stewart requests that the court hold defendants jointly liable for the payment of reasonable attorney's fees and costs under 28 U.S.C. Section 2412, 5 U.S.C. Section 552, A, 4, E, I, and Bivens. Plaintiff Stewart further requests that this court order defendants to remove her name from the TSDB and instruct them to abstain from including her name in any other secret database used to carry out human torture and experimentation or any other improper purpose. Winter Calvert. The foregoing allegations are re-alleged and incorporated herein. Plaintiff Calvert was nominated and included in the TSDB devoid of supporting particularized derogatory information about him, without having been given any notice or opportunity to rebut, and based on his First Amendment protected activities. Defendant FBI does not possess and has never corroborated particularized derogatory information linking Plaintiff Mr. Calvert to any act of terrorism. Plaintiff Calvert has never been convicted of any crime. On or around December 2016, Mr. Calvert sustained a medical emergency while at his mother's house. While laying on the floor suffering from what he later learned were severe blood clots, 2 deputy sheriffs of the Brazoria County didn't allow the ambulance to drive up right away to the driveway to take him to a hospital. While Plaintiff Mr. Calvert laid on the floor of his mother's house, in severe pain and on the brink of death, 2 Brazoria County deputy sheriffs entered the premises. Both deputy sheriffs asserted that they could not allow anyone into the premises until they inspected them thoroughly, since they had to secure the area because they had been told that a suspected terrorist lived there. As a result of the sheriff's directives, it took more than an hour for Plaintiff Calvert to receive emergency medical attention, almost costing him his life. The only persons that lived in that property were Plaintiff Mr. Calvert and his 87-year-old mother, who was a retired attorney licensed in the state of Texas. Plaintiff Calvert's inclusion in the TSDB subjected him to defendants' illegal break-ins to his home, physical and electronic surveillance, and organized stalking since at least 2011 in violation of his rights under the 1st, 4th, 5th, 6th, and 14th Amendments of the United States Constitution and the Convention Against Torture, and causing him egregious mental anguish, anxiety, and suffering. As a result of Plaintiff Calvert's illicit inclusion in the TSDB, since at least 2016 he has undergone painful and disabling DEW on a daily basis to various parts of his body, microwave burns, blood clots, inflicting on him severe and debilitating sleep deprivation, anxiety, and physical and mental pain and suffering. Despite his impeccable professional qualifications, Mr. Calvert's inclusion in the TSDB and the organized stalking directed at him forced him to be unemployed during 2 years and 8 months beginning in 2013. Plaintiff Calvert's inclusion in the TSDB subjected him since 2011 to illegal break-ins to his home, vandalizing of his property, physical and electronic surveillance, and organized stalking, electronic interferences and hacking, in violation of his rights under the 1st, 4th, 5th, 6th, 8th, and 14th Amendments of the Convention Against Torture, resulting in damages estimated in an amount no less than $12 million. $12 million. Since 2016, Plaintiff Calverts has suffered constant DEW attacks perpetrated from satellites and cell towers valued in $21 million. $21 million. Plaintiff Calvert has sustained permanent brain injuries and developed a permanent physical condition similar to Havana syndrome. The permanent physical damages and mental pain and suffering this condition causes him are estimated in an amount no less than $20 million. $20 million. Aside from the payment of the damages amounting to $53 million, Plaintiff Calvert requests that in light of the malicious intent behind his targeting, experimentation, torture and suffering, the court hold defendants Ray, Cable Jr., Mayorkas and Weinstein jointly liable to him for punitive damages for the amount of $159 million. $159 million. Plaintiff Calvert also requests that FBI and DHS be ordered to pay him damages for the illegal disclosure of his inclusion in the TSDB, with the social, professional and personal repercussions, suffering, anxiety, and loss that it caused him. These damages are estimated in minimum amount of $1 million per year, depending on the quality and quantity of the derogatory information shared outside of the agency and to be calculated when defendants provide the evidence of the extent of the disclosure. Plaintiff Calvert requests that the court hold defendants jointly liable in the payment of reasonable attorney's fees and costs under 28 U.S.C. Section 2412, 5 U.S.C. Section 552, A, 4, E, I, and Bivens. Plaintiff Calvert specifically requests that this court order defendants to remove his name from the TSDB's NIS/handling codes 3/ for categories, recall all lists containing his name, and instruct them to abstain from including his name in any other illegal database used to carry out human torture, experimentation, and/or any other improper purpose. Plaintiff Armando Della Torre, Berta Jasmine Della Torre, and J.D. The foregoing allegations are re-alleged and incorporated herein. As a result of defendants illegally including plaintiffs Armando and Jasmine Della Torre and their minor daughter J.D. as non-investigative subjects under Handling Code 3 or 4 in the TSDB since at least 2019, they have sustained substantial damages deriving from the unconstitutional deprivations of their rights protected under the 1st, 4th, 5th, 6th, 8th, and 14th Amendments of the United States Constitution and the Convention Against Torture. As a result of being targeted, plaintiffs Armando and Berta Jasmine Della Torre have suffered illegal break-ins to their home, physical and electronic surveillance and organized stalking since 2018. Rogue stalkers follow Mr. Della Torre in packs at any given time, 7 days a week. The damages plaintiff Armando Della Torre and Berta Jasmine have sustained as a result of defendants' joint liability stemming from the unconstitutional and illegal organized stalking part of their targeting is estimated in an amount no less than $5 million, $5 million, each, for a total of $10 million, $10 million. As a result of being targeted since 2018, plaintiff Berta Jasmine suffers from intolerable V2K that almost cost her life. As a result of the V2K, she has sustained damages amounting to $50 million, $50 million. The physical pain and suffering that plaintiffs Armando and Berta Jasmine Della Torre have sustained as a result of defendants' joint liability stemming from the DEW attacks they have suffered since 2018 as a result of their targeting is estimated in an amount no less than $15 million, $15 million, each, for a total of $30 million, $24 million. Both plaintiffs Armando and Berta Jasmine Della Torre have sustained permanent brain damage that has caused them the condition known as Havana syndrome as a result of defendants' joint liability stemming from the DEW attacks they have suffered since 2018 as a result of their targeting. The permanent physical damages for each of them is estimated in $20 million, $20 million, for a total of $40 million, $40 million. Armando and Berta Jasmine's daughter, J.D., suffers from V2K since at least August 2022. The permanent damages this torture has caused and will continue to cause her developing brain is unknown at this time. The suffering, fear and anguish the V2K has caused her is estimated in an amount no less than $10 million, $10 million. Aside from the payment of the damages alleged above, Plaintiffs' dilatory request that in light of the malicious intent behind their targeting, experimentation, torture and suffering, the court hold defendants Ray, Cable Jr., Mayorkas and Weinstein jointly liable to them for a reasonable amount in punitive damages in an amount estimated at $480 million. $480 million. Plaintiffs Armando and Berta Jasmine de la Torre also request that defendant FBI and defendant DHS be held jointly liable for the payment of the damages they have sustained for the illegal disclosure of their inclusion in the TSDB that has them caused considerable and irreparable social, professional, and personal repercussions, suffering, anxiety and loss. These damages are estimated in minimum amount of $1 million each per year, depending on the quality and quantity of the derogatory information shared outside of the agency and to be calculated when defendants provide the evidence of the extent of the disclosure. Plaintiffs Armando, Berta Jasmine de la Torre and JD request that the court hold defendants jointly liable in the payment of reasonable attorney's fees and costs under 28 U.S.C. Section 2412, 5 U.S.C. Section 552, A, 4, E, I, and Bivens. Plaintiffs de la Torre specifically request that this court order defendants to remove their names as well as that of their daughter JD from the TSDB and instruct defendants to abstain from including them in any other illegal database used to carry out human torture and experimentation or any other improper purpose. Deborah Mahanger and daughter L.M. The foregoing allegations are re-alleged and incorporated herein. On or around 2009, Plaintiff Mahanger realized she had become a targeted individual. Plaintiff Mahanger's nomination was entirely devoid of supporting particularized derogatory information linking her to terrorist activity. She was not given any notice or opportunity to rebut her nomination. As a result of defendants illegally including Plaintiff Mahanger as non-investigative subject under Handling Code 3 or 4 in the TSDB since at least 2009, and her daughter LM added to the TSDB sometime after birth, have sustained substantial damages deriving from the unconstitutional deprivations of their rights protected under the 1st, 4th, 5th, 6th, 8th, and 14th Amendments of the United States Constitution and the Convention Against Torture. Defendants FBI's and DHS reply to Plaintiff Mahanger Privacy Act requests provided no information about their inclusion in the TSDB. Plaintiff Mahanger's inclusion in the TSDB subjected her since 2009 to illegal break-ins to her home, vandalizing of her property, physical and electronic surveillance, and organized stalking for over 2 decades consisting of a plethora of abuses including job blocking, petty theft, electronic interferences and hacking. Both Plaintiff Mahanger and her daughter LEM have suffered each damages resulting from organized torture estimated in an amount no less than $13 million, $13 million, and $5 million, $5 million, respectively. Plaintiff Mahanger and her daughter LM suffer from painful and disabling directed energy weapons, DEW. These physical torture and damages are estimated in an amount no less than $36 million, $36 million, and $15 million, $15 million, respectively. The constant DEW attacks perpetrated against Plaintiff Mahanger and her daughter LM also include remote neural monitoring and subliminal messaging have caused them the condition known as Havana syndrome, consisting of permanent brain and physical injuries estimated at $20 million each. Plaintiff Mahanger suffers from V2K since at least 2017. The suffering and anguish the V2K has caused her is estimated in an amount no less than $50 million, $50 million. Aside from the payment of the damages amounting set forth above, plaintiffs Deborah Mahanger and LM request that in light of the malicious intent behind their targeting, experimentation, torture and suffering, defendants Ray, Cable Jr., Mayorkas and Weinstein are held to be jointly liable to them for a reasonable amount in punitive damages estimated at $336 million. $336 million. Plaintiff Mahanger also requests that FBI and DHS be ordered to pay her damages for the illegal disclosure of her inclusion in the TSDB, with the social, professional and personal repercussions, suffering, anxiety, and loss that it caused her. These damages are estimated in minimum amount of $1 million per year, depending on the quality and quantity of the derogatory information shared outside of the agency and to be calculated when defendants provide the evidence of the extent of the disclosure. Plaintiffs Mahanger and LM request that the court impose on defendants reasonable attorney's fees and costs under 28 U.S.C. Section 2412 and 5 U.S.C. Section 552A 4E(I). Plaintiff Mahanger further requests that this court order defendants to remove her name as well as that of her daughter LAM from the TSDB and instruct them to abstain from including them in any other illegal database used to carry out human torture, experimentation, and/or any other improper purpose. Lindsay J. Penn. The foregoing allegations are re-alleged and incorporated herein. On information and/or belief, in 2014 Plaintiff Penn's name was added to the TSDB. Plaintiff Penn's nomination was devoid of supporting particularized derogatory information linking her to terrorist activity. Defendant FBI did not give her any notice or opportunity to rebut her nomination. As a result of defendants illegally including Plaintiff Penn as a non-investigative subject under Handling Code 3 or 4 in the TSDB since at least 2016, she has sustained substantial damages deriving from the unconstitutional deprivations of her rights protected under the 1st, 4th, 5th, 6th, 8th, and 14th Amendments of the United States Constitution and the Convention Against Torture. On December 1, 2014, the day of her son's birthday, Plaintiff Penn began suffering the effects of VTK. She thought she had developed a mental illness. However, it wasn't until 2016 that Plaintiff Penn realized she was a TI and the voices she heard 24 hours a day were the result of V2K. As a result of her illicit inclusion in the TSDB, Plaintiff Penn has suffered illegal break-ins to her home, physical and electronic surveillance, and organized stalking. Defendants' operatives carry out their stalking/intimidation tactics even when she goes on vacation. The damages Plaintiff Penn has sustained as a result of defendants' joint liability stemming from the unconstitutional and illegal organized stalking part of her targeting is estimated in an amount no less than $7 million. $7 million. As a result of being targeted since 2014, Plaintiff Penn suffers from intolerable V2K that substantially interferes with every aspect of her life. As a result of the V2K, she has sustained damages amounting to $80 million. $80 million. The damages Plaintiff Penn has sustained as a result of defendants' joint liability stemming from the DEW attacks she has suffered since 2016 as a result of her targeting is estimated in an amount no less than $21 million. $21 million. The constant DEW attacks perpetrated against Plaintiff Penn have caused her a condition known as Havana syndrome consisting of permanent brain and physical injuries estimated at $20 million. $20 million. Aside from the payment of the damages amounts set forth above, Plaintiff Penn requests that in light of the malicious intent behind their targeting, experimentation, torture and suffering, defendants Ray, Cable Jr., Mayorkas and Weinstein are held to be jointly liable to her for a reasonable amount in punitive damages estimated at $354 million. $354 million. Plaintiff Penn also requests that FBI and DHS be ordered to pay her damages for the illegal disclosure of her inclusion in the TSDB, with the social, professional and personal repercussions, suffering, anxiety, and loss that it caused her. These damages are estimated in minimum amount of $1 million per year, depending on the quality and quantity of the derogatory information shared outside of the agency and to be calculated when defendants provide the evidence of the extent of the disclosure. Plaintiff Penn requests that the court impose on defendants reasonable attorney's fees and costs under 28 U.S.C. Section 2412 and Bivens. Plaintiff Penn further requests that this court order defendants to remove her name from the TSDB and instruct defendants to abstain from including it in any other illegal database used to carry out human torture and experimentation or any other improper purpose. Melody and Hobson. The foregoing allegations are re-alleged and incorporated herein. Around 2014, Plaintiff Melody Hobson began to be followed around her hometown in Pasadena, Texas. As a result of defendants illegally including Plaintiff Hobson as a non-investigative subject under Handling Code 3 or 4 in the TSDB since at least 2014, she has sustained substantial damages to her property and person deriving from the unconstitutional deprivations of her rights protected under the 1st, 4th, 5th, 6th, 8th, and 14th Amendments of the United States Constitution and the Convention Against Torture. Plaintiff Melody Hobson became aware in 2016 that she was a TI. She was nominated and included in the TSDB devoid of supporting particularized derogatory information, without having been given any notice or opportunity to rebut her nomination. Defendants FBI's and DHS reply to Plaintiff Hobson Privacy Act requests provided no information about her inclusion in the TSDB. Specifically, as a result of being targeted. Plaintiff Hobson has suffered physical and electronic surveillance and organized stalking. As a result of this, she has become socially ostracized, lost friends, and became distanced from her family. In 2016, Plaintiff Hobson started hearing V2K without knowing it was a form of torture. Doctors opined she had schizophrenia. Even though by 2019 the doctors concluded she was not schizophrenic, they have refused to acknowledge that she is the victim of V2K attacks. Also, since 2016, she has been the victim of DEW attacks that cause her burns throughout her body, and in particular her feet and genital area. The damages Plaintiff Hobson has sustained as a result of defendants' joint liability stemming from the unconstitutional and illegal organized stalking part of her targeting is estimated in an amount no less than $9 million. $9 million. Since 2016, Plaintiff Hobson suffers from intolerable V2K that substantially interferes with every aspect of her life. As a result of the V2K, she has sustained damages amounting to $70 million. $70 million. The damages Plaintiff Hobson has sustained as a result of defendants' joint liability stemming from the DEW attacks she has suffered since 2016 as a result of her targeting is estimated in an amount no less than $21 million. $21 million. The constant DEW attacks perpetrated against Plaintiff Hobson have caused her a condition known as Havana syndrome, consisting of permanent brain and physical injuries estimated at $20 million. $20 million. Aside from the payment of the damages amounts set forth above, Plaintiff Hobson requests that in light of the malicious intent behind their targeting, experimentation, torture and suffering, defendants Ray, Cable Jr., Mayorkas and Weinstein are held to be jointly liable to her for a reasonable amount in punitive damages estimated at $120 million. $120 million. Plaintiff Hobson also requests that FBI and DHS be ordered to pay her damages for the illegal disclosure of her inclusion in the TSDB, with the social, professional and personal repercussions, suffering, anxiety, and loss that it caused her. These damages are estimated in minimum amount of $1 million, $1 million per year, depending on the quality and quantity of the derogatory information shared outside of the agency and to be calculated when defendants provide the evidence of the extent of the disclosure. Plaintiff Hobson requests that the court impose on defendants reasonable attorney's fees and costs under 28 U.S.C. Section 2412, 5 U.S.C. Section 552, A, 4, E, I, and Bivens. Plaintiff Hobson further requests that this court order defendants to remove her name from the TSDB and instruct them to abstain from including it in any other illegal database used to carry out human torture, experimentation, and/or any other improper purpose. Anna Robertson Miller. The foregoing allegations are re-alleged and incorporated herein. Defendant FBI does not have and has never had nor corroborated particularized derogatory information linking plaintiff Anna Robertson Miller to any act of terrorism. She specifically demands her name be removed from the TSDB. Plaintiff Anna Robertson Miller became aware in 2016 that she was a TI. Defendant FBI nominated and included her in the TSDB devoid of supporting particularized derogatory information. She was not given any notice or opportunity to rebut her nomination. Plaintiff Miller has been the victim of organized stalking in public places, motor vehicle noise campaigns such as honking and loud accelerating around her or in front of her house. She has undergone break-ins to her home, physical and electronic surveillance and organized stalking in violation of her rights under the 1st, 4th, 5th, 6th, and 14th Amendments of the Convention Against Torture. Plaintiff Miller believes her targeting could have begun as early as 2013 as she continuously got rejected from all jobs she applied for, albeit her preparation and experience. She estimates her damages resulting from the organized stalking in $7 million. $7 million. In 2019, Plaintiff Miller started having painful, disabling DEW attacks to various parts of her body and sleep deprivation. Prior to the filing of this complaint, her attacks have substantially increased in intensity and duration. She estimates her physical and mental pain and suffering resulting from the DEW attacks in $12 million. $12 million. As a result of Plaintiff Miller's inclusion in the TSDB since at least 2016 and the constant DEW attacks perpetrated against her since then, she has sustained permanent brain injuries and developed a permanent physical condition known as Havana syndrome. The permanent physical damages and mental pain and suffering this condition causes her are estimated in an amount no less than $20 million. $20 million. Aside from the payment of the damages amounts set forth above, Plaintiff Miller requests that in light of the malicious intent behind their targeting, experimentation, torture and suffering, defendants Ray, Cable Jr., Mayorkas and Weinstein are held to be jointly liable to her for a reasonable amount in punitive damages estimated at $117 million. $117 million. Plaintiff Miller also requests that FBI and DHS be ordered to pay her damages for the illegal disclosure of her inclusion in the TSDB, with the social, professional and personal repercussions, suffering, anxiety, depression, and loss that it caused her. These damages are estimated in a minimum amount of $1 million per year, depending on the quality and quantity of the derogatory information shared outside of the agency and to be calculated when defendants provide the evidence of the extent of the disclosure. Plaintiff Miller requests that the court impose on defendants joint liability for the payment of reasonable attorney's fees and costs under 28 U.S.C. Section 2412, 5 U.S.C. Section 552, A, 4, E, I, and Bivens. Ms. Miller specifically requests that this court order defendant FBI to remove her name from the TSDB and instruct defendants to abstain from including it in any other illegal database used to carry out human torture, experimentation, and/or any other illicit purpose. Devin Fraley. The foregoing allegations are re-alleged and incorporated herein. Plaintiff Fraley was nominated and included in the TSDB devoid of supporting particularized derogatory information, without having been given any notice or opportunity to rebut her nomination. Defendant FBI and defendant DHS reply to Plaintiff Fraley's Privacy Act requests without providing any about her inclusion in the TSDB as she requested. As a result of defendant FBI illegally including Plaintiff Fraley as a non-investigative subject under Handling Code 3 or 4 in the TSDB since at least 2012, she has sustained substantial damages to her property and person deriving from the unconstitutional deprivation of her rights protected under the 1st, 4th, 5th, 6th, 8th, and 14th Amendments of the United States Constitution and the Convention Against Torture. Specifically, as a result of being targeted, Plaintiff Fraley has suffered physical and electronic surveillance and organized stalking. Towards 2016, Plaintiff Fraley's targeting increased in intensity. During that year, she started hearing artificial tinnitus and V2K, torturing her 24 hours a day and severely interfering with her life. As a result of the V2K, she has sustained damages amounting to $70 million. $70 million. Also since 2016, Plaintiff Fraley has been the victim of DEW attacks that cause her burns to her feet, genital area, suffering damages estimated in $21 million. $21 million. The damages Plaintiff Fraley has sustained as a result of defendants' joint liability stemming from the unconstitutional and illegal organized stalking part of her targeting is estimated in an amount no less than $11 million. $11 million. The constant DEW attacks perpetrated against Plaintiff Fraley have caused her symptoms indicative of Havana syndrome consisting of permanent brain and physical injuries estimated at $20 million. $20 million. Aside from the payment of the damages amounts set forth above, Plaintiff Fraley requests that in light of the malicious intent behind their targeting, experimentation, torture and suffering, defendants Ray, Cable Jr., Mayorkas and Weinstein are held to be jointly liable to her for a reasonable amount in punitive damages estimated at $366 million. $366 million. Plaintiff Fraley also requests that FBI and DHS be ordered to pay her damages for the illegal disclosure of her inclusion in the TSDB, with the social, professional and personal repercussions, suffering, anxiety, and loss that it caused her. These damages are estimated in minimum amount of $1 million per year, depending on the quality and quantity of the derogatory information shared outside of the agency and to be calculated when defendants provide the evidence of the extent of the disclosure. Plaintiff Fraley requests that the court impose on defendants reasonable attorney's fees and costs under 28 U.S.C. Section 2412, 5 U.S.C. Section 552, A, 4, E, I, and Bivens. Plaintiff Fraley further requests that this court order defendant FBI to remove her name from the TSDB and instruct defendants to abstain from including it in any other illegal database used to carry out human torture, experimentation, and/or any other improper purpose. Susan Olson. The foregoing allegations are re-alleged and incorporated herein. Defendant FBI does not have and has never had nor corroborated particularized derogatory information linking plaintiff Susan Olson to any act of terrorism. Despite that, her name appears in the TSDB's NIS/handling code 3/4 lists. She specifically demands her name be removed from the TSDB. Plaintiff Susan Olson became aware in 2015 that she was a TI. She was nominated and included in the TSDB devoid of supporting particularized derogatory information, without receiving any notice or opportunity to rebut her nomination. Since at least 2015, Plaintiff Olson has been the victim of organized stalking in public places, motor vehicle noise campaigns such as honking and loud accelerating around her or in front of her house. She has undergone break-ins to her home, car, bank safety deposit box, interception and theft of postal mail, physical and electronic surveillance and organized stalking in violation of her under the 1st, 4th, 5th, 6th, and 14th Amendments of the United States Constitution and the Convention Against Torture. She has suffered her severe anguish, mental pain and suffering and damages as a direct consequence of defendants' organized stalking estimated in an amount exceeding $8 million. $8 million. In 2016, Plaintiff Olson started having painful, disabling various parts of her body that also caused sleep deprivation. Prior to the filing of this complaint, her attacks have substantially increased in intensity and duration. She estimates her physical and mental pain and suffering resulting from the DEW attacks in $21 million. $21 million. As a result of Plaintiff Olson's inclusion in the TSDB since at least 2016 and the constant DEW attacks perpetrated against her since then, she has sustained permanent brain injuries and symptoms indicative that she has developed the permanent physical condition known as Havana syndrome. The permanent physical damages and mental pain and suffering this condition causes her are estimated in an amount no less than $20 million. $20 million. Aside from the payment of the damages amounts set forth above, Plaintiff Olson requests that in light of the malicious intent behind their targeting, experimentation, torture and suffering, defendants Ray, Cable Jr., Mayorkas and Weinstein are held to be jointly liable to her for a reasonable amount in punitive damages estimated at $147 million. $147 million. Plaintiff Olson also requests that defendant FBI and defendant DHS be ordered to pay her damages for the illegal disclosure of her inclusion in the TSDB, with the social, professional and personal repercussions, suffering, anxiety, and loss that it caused her. These damages are estimated in minimum amount of $1 million per year, depending on the quality and quantity of the derogatory information shared outside of the agency and to be calculated when defendants provide the evidence of the extent of the disclosure.
Okay, I have to stop here because it sounds amazing if you're a targeted individual, that dollar amount, millions and millions and millions of dollars. And for those of you that are still watching and you're a TI, you're going to feel like, wow, that's how much money I can get or possibly get. Those are just numbers they're throwing out there. And since they're asking for punitive damage, so punitive damage is asking the judge to punish the defendant for breaking the law and also to deter any future reoccurrence. So it's asking for the judge to pay out a huge amount of money to punish the defendant and let people know don't do this again in the future. And that's the whole point of punitive damage. So it could be a number that the judge feel like it could give out to punish the person. And yeah, if they get it, it could be in hundreds of millions of dollars. But let's step back a little bit. Right here, it said, depending on the quality of the derogatory information shared outside of the agency and to be calculated when defendants provide the evidence of the extent of the disclosure. So they're asking the defendant to provide the evidence, and based on the evidence provided by the defendant, that's how much the judge should punish the defendant for breaking the law. If you're the defendant, what would you do? Would you hand over this information, this evidence? Let's say you do have it. Would you hand it over so the judge can punish you? Regardless if it's there or not, it's up to the plaintiff to provide the evidence. But if the plaintiff do not have that evidence, then the plaintiff should not file a lawsuit. That's all I'm saying. I'm not bashing on the lawsuit. And I would tell you, if you got the evidence, oh, you got the evidence, you got a good case, and go and sue them and get that money. Let people know. I would tell you that. But it's the fact that I know, based on this document's going on for the last 2 hours, they don't have the evidence. And right here, they've been repeating this for the last 20 minutes, many times in the last 10, 20 minutes, when defendants provide the evidence of the extent of the disclosure. They need the defendants to provide the actual evidence to seal the case. And the defendant's not going to do that and then get punished by the judge and pay out millions of dollars. They're not going to do that. That's just common sense. If this list really do exist, and if on the list actually has the plaintiff's name on it, okay? So how are they going to get all these millions of dollars in punitive damages when they do not have evidence beyond reasonable doubt? It's not going to happen. It's not going to happen. How is it going to happen? It's not. So, and then throwing out millions and millions of dollars that are not punitive, just their daily lives being ruined. I get it. They have to provide income showing how much money they average, how much they make per year. And now that they can work and calculating, okay, into the future and how much they can lose out on retirement, pensions and stuff like that, and medical costs, seeing doctors, all this stuff, they're going to have to provide all those and kind of like get an idea of how much on average they're suffering and losing financially. And then calculate that, estimating into the future. So it's not just like random numbers they can throw out. And it's punitive damage. They can request $147 million right here, $147 million. They can request that if they win the case, then the judge could grant that. But can they win the case when the defendant are the one holding the evidence? And the defendant will have to pay millions of dollars if the defendant loses the case, but they hold the evidence. Do you think that defendant will provide the evidence? I'm going to say no. That is just straight up common sense. I'm not trying to be an agent. I'm not trying to be someone that try to talk down on this lawsuit. I'm just telling you like it is. Straight up. I'm not bullshitting you guys. The one piece of evidence that they need, they don't have. And this thing's been going on for the last 2 hours. I've been playing this. I'm just listening to it. I'm like, this is jargon. The only one making money are the attorneys. And the ones losing money are both sides, the defendant and the plaintiffs. But if the defendant win, then the plaintiffs will have to pay for their attorney's fees. And vice versa. But I don't see how the plaintiff can win when they don't have the actual piece of evidence that they need to win the case. The defendant has it. So it'll be interesting going forward, and I'll be following this case. I want to know what's going to happen And there might be surprises. Who knows? Maybe they will just win. Maybe I'm sure there's a lot more information that's not being mentioned here that they're going to wait till trial. That's if it goes to trial. And if it goes to trial, it'll be really, really expensive. Because right now, the attorney already talked about she's spending about 500 hours reading other people's stuff they send in. So she already spent about 500 hours, give it about $300 an hour. That's like even $50,000 on the plaintiff side. Just an estimate. I don't really know. Maybe she's doing it for free, but if they go to trial, oh man, it's gonna be so much more. See, I'm okay with the TI wanting to file a lawsuit against the government, even though I tell you it's not the government. But if you feel like you want to sue the government because of this, that's fine. But what I'm not okay with is when there's no evidence, yet the TI still wants to file a lawsuit when there's no evidence. That, to me, is the TIs are in a state of trance. Their mind is in a state of trance, and their mind is blocked from realizing that the lawsuit sounds good, but then what about the evidence? And that's what they're missing. But yet they still go ahead and file a complaint lawsuit because the department did not respond to their request of Privacy Act information or request of this list. Because they did not respond to their letter, now let's go ahead and sue them. And then they went ahead and started making all these other claims along the way, and then demanding all this dollar amount. All that takes time, but then they do not think, they don't have the evidence. And ask whoever typed this out, probably the lawyer, she knows there's no evidence. She already knows the outcome. I mean, she just want to do this just to do it. I don't know what her motive is. I don't know if she's getting paid or pro bono, but she's doing it. She knows. I mean, she's a lawyer. She knows they're missing the evidence, but she's still sitting there typing it out. And the TIs, the plaintiff, are believing they have a case, telling her, "Oh, I want $8 million, and I also want punitive damage of $50 million." Like, you see how the TI went through that behavior when the reality is that they don't have the evidence to prove their case. But in their mind, they believe they do, and that's because the lower voice to skull manipulates the TI's ideas, their what they think about, and their thought process. Because I know these TIs they're smart people. It sounds like they have good jobs. Some of them, they're regular normal people, but just going through this gang stalking. They're special people. They're smart people. But when the lower voice to skull kicks in, it can really manipulate a person's thought patterns and their thought process. And this is one good example that these plaintiffs actually spend all that time talking to the attorney, moving forward with this lawsuit, telling the attorney how much money he or she wants. In reality, there's no evidence. The one piece of information they need to win their case is the evidence, and they don't have it. It's in the defendant's possession if they have it, and the defendant's not going to give it up. So that's what I'm not okay with. I'm not going to tell TI, go file a lawsuit against them when the TI have no evidence. I'm not going to tell the TI to go do that. Why would I tell the TI to do that? But if the TI feels like the TI needs to do it, then the TI should do it. And I'm not going to BS and be like, oh yeah, you're going to win this case, you should do it. Yeah, go do it. It could cost a lot of money, but who cares? Just go do it. People need to know. People will know if the case is won, because it's a lot of money. They're asking for 1.3 billion. If they win this case, everyone's going to know, and that's what they're attempting, and good for them. And I want to follow this case. So let's finish this up because this stream is getting too long. I need to end this. It's a Saturday and I need to go do some stuff. have to go to lunch in a little bit. So maybe another 10 minutes of this, if this continues for 10 more minutes. Let's see how much more. Oh, we're actually almost at the end.
Disclosure. Plaintiff Olson requests that the court impose joint liability on defendants for the payment of the damages alleged herein and reasonable attorney's fees and costs under 28 U.S.C. Section 2412 and Bivens. Ms. Olson specifically requests that this court order defendant FBI to remove her name from the TSDB and instruct defendants to abstain from including it in any other illegal database used to carry out human torture, experimentation, and/or any other illicit purpose. Jean Kong. The foregoing allegations are re-alleged and incorporated herein. Jean Kong, of legal age, United States citizen, single, attorney at law, resident of East Brunswick, New Jersey, became aware he was a TI in 2015, but recognizes he may have been a TI for a longer time. Plaintiff Kong was nominated and included in the TSDB devoid of supporting particularized derogatory information, without receiving any notice or opportunity to rebut his nomination. Although he believes his targeting began prior to 2015, it didn't become evident until 2015. As a result of defendants illegally including Plaintiff Kong as a non-investigative subject under Handling Code 3 or 4 in the TSDB since at least 2015, he has sustained substantial damages to his property and person deriving from the unconstitutional deprivations of his rights protected under the 1st, 4th, 5th, 6th, 8th, and 14th Amendments of the United States Constitution and the Convention Against Torture. As a result of being targeted, Plaintiff Kong has suffered physical and electronic surveillance and organized stalking in multiple areas of his life, causing him severe anguish, mental pain, and suffering and damages exceeding $8 million. $8 million. Since Plaintiff Kong was admitted to the New Jersey bar, the organized stalking attacks have decreased, although they have not stopped altogether. Upon the conclusion of discovery, Plaintiff Kong reserves his right to claim damages resulting from DEW attacks directed at him and the permanent damages they may have caused him since his name was included in the TSDB since he developed artificial tinnitus, and indicative of satellite tracking and DEW attacks. Aside from the payment of the damages amounts set forth above, Plaintiff Kong requests that in light of the malicious intent behind his targeting, experimentation, torture and suffering, defendants Ray, Cable, Mayorkas and Weinstein are held to be jointly liable for the payment of a reasonable amount in punitive damages estimated at $24 million. $24 million. Plaintiff Kong also requests that the court hold defendant FBI and defendant DHS jointly liable in the payment of his for their disclosure of his inclusion in the TSDB, with the social, professional and personal repercussions, suffering, anxiety, and loss that it caused her. These damages are estimated in minimum amount of $1 million per year, depending on the quality and quantity of the derogatory information shared outside of the agency, to be calculated when defendants provide the evidence of the extent of the disclosure. Plaintiff Kong requests that the hold defendants jointly liable for the reasonable attorney's fees and costs under 28 U.S.C. Section 2412 and Bivens. Plaintiff Kong specifically requests that this court order defendants to remove his name from the TSDB's NIS/handling codes 3/4 categories, recall all lists containing his name, and instruct them to abstain from including his name in any other illegal database used to carry out human torture, experimentation, and/or any other improper purpose.
Now, I just want to say something for the plaintiff side. It is very possible that this database, this list exists, and the plaintiff's names are on there, and the plaintiffs actually got a hold of the list. So it's very possible the plaintiff got the evidence with the plaintiff's name on it. And during discovery, they're going to ask the defendant to provide it. And the defendant's not going to provide it. Then later on, the plaintiff side could provide this evidence and make it dramatic. That way they can catch the defendant in a lie. So that is very possible. Very possible. And that would be a great way to support all their claims. And the judge will most likely grant the punitive damage because it shows intent that they lie by not providing the evidence during the discovery phase. When the defendant actually have it, they say they don't have it. Then the plaintiff later on shows it to the judge that it exists. It has the signature of some of those defendants on there, then it'll be a dramatic turn of event. Then the judge will see, wow, the defendant actually purposely lied. So they do have intent to harm. And that way, punitive damage would be acceptable. And to punish the defendant, the judge could award the $1.3 billion, maybe even more, maybe $2 billion, who knows? And the defendant will appeal, and that's going to continue. So that is a possibility. But it's very unlikely.
Purpose. Plaintiff Jason Faust. The foregoing allegations are re-alleged and incorporated herein. Plaintiff Jason Faust was nominated and included in the TSDB devoid of supporting particularized derogatory information, without receiving any notice or opportunity to rebut his nomination. Although he believes his targeting began prior to 2015, it didn't become evident until 2016. Defendant FBI and Defendant DHS replied to his Privacy Act requests, refusing to provide any information about his inclusion in the TSDB. As a result of defendants illegally including Plaintiff Faust as a non-investigative subject under Handling Code 3 or 4 in the TSDB since at least 2015, he has sustained substantial damages to his property and person deriving from the unconstitutional deprivations of his rights protected under the 1st, 4th, 5th, 6th, 8th, and 14th Amendments of the United States Constitution and the Convention Against Torture. As a result of being targeted, Plaintiff Faust has suffered physical and electronic surveillance and organized stalking. He gets dangerously stalked and chased while driving his vehicle. The organized stalking that he has sustained as a result of being part of the nefarious experiment has caused him severe anguish, mental pain, and suffering and damages exceeding $8 million. $8 million. Since 2016, Plaintiff Faust has been the victim of DEW attacks that cause severe tinnitus, burns, bruises throughout his body, perpetrating damages estimated in $21 million. $21 million. The constant DEW attacks perpetrated against Plaintiff Faust display symptoms associated to a condition known as Havana syndrome, consisting of permanent brain and physical injuries estimated at $20 million. $20 million. Aside from the payment of the damages amounts set forth above, Plaintiff Faust requests that in light of the malicious intent behind his targeting, experimentation, torture and suffering, defendants Ray, Cable Jr., Mayorkas and Weinstein are held to be jointly liable to him for a reasonable amount in punitive damages estimated at $147 million. $147 million. Plaintiff Faust also requests that the court hold Defendant FBI and Defendant DHS jointly liable in the payment of his for their disclosure of his inclusion in the TSDB, with the social, professional and personal repercussions, suffering, anxiety, and loss that it caused him. These damages are estimated in minimum amount of $1 million per year, depending on the quality and quantity of the derogatory information shared outside of the agency, to be calculated when defendants provide the evidence of the extent of the disclosure. Plaintiff Faust requests that the hold defendants jointly liable for the reasonable attorney's fees and costs under 28 U.S.C. Section 2412, 5 U.S.C. Section 552, A, 4, E, I, and Bivens. Plaintiff Faust specifically requests that this court order defendants to remove his name from the TSDB's NIS/handling codes 3/for categories, recall all lists containing his name, and instruct them to abstain from including his name in any other illegal database used to carry out human torture, experimentation, and/or any other improper purpose. Prayer for relief. Wherefore, plaintiffs respectfully request that this court exercise its jurisdiction and issue the following relief. Issue a writ of mandamus to defendants Ray, Cable Jr., Mayorkas and Weinstein to comply with their ministerial duty to uphold the United States Constitution, and consequently eliminate the NIS/handling code 3/4 lists from the TSDB and end the human experimentation program that targets individuals. Enter judgment declaring that Defendant DHS, Defendant FBI, and Interagency Operation TSC violated the Privacy Act. Enter judgment declaring that defendants violated the Administrative Procedure Act, 5 U.S.C. Sections 702, 706. Enter judgment declaring that plaintiffs and TJ members' inclusion in the TSDB violates their rights protected under the 1st, 4th, 5th, 6th, and 14th Amendments of the Constitution of the United States and ordering their removal from it. Enter judgment compelling defendant FBI and the TSC to recall and dismantle the NIS/handling code 3/4 portion of the TSDB. Enter judgment declaring repugnant to the United States Constitution the human experimentation program on targeted individuals as it violates the following: the 1st, 4th, 5th, and 6th Amendments of the Constitution of the United States by punishing its victims for the exercise of free speech, conducting illegal search and seizures of their person and things, and depriving them of property and liberty without due process. The 8th Amendment as it constitutes totalitarian, cruel, and unusual punishment without the conviction of a crime. The 14th Amendment as the experimentation program disproportionately targets against women and conservatives, and the United Nations Convention 1753 against torture and other cruel, inhuman, or degrading treatment or punishment, ratified by the United States of America in 1994. Issue a permanent injunction ordering defendants to immediately eliminate and TJ members' names from the TSDB and ban defendants from including them in any other secret, catalogs, lists, compendium, or indexes as described herein to continue the targeting of them. Recall and recover all catalogs, lists, compendiums, or indexes disseminated to law enforcement, private companies, individuals, and entities that contain plaintiffs' names and personal identifiers. Abstain from devising, perpetrating, and enabling the surveillance, organized stalking, and psychological torture against plaintiffs and TJ members through defendant DHS Fusion Centers network, contractors such as InfraGard, Citizen Corps, and/or any other person or entity defendants concoct, collude with, or hire for those purposes. Permanently enjoin defendants from creating another experimentation program or list to include plaintiffs or TJ members. Hold defendants jointly liable for plaintiffs' damages and order them to pay them the amounts alleged for each one as specified in the paragraphs above incorporated herein. Order defendants to fund the creation of a court monitoring system to ensure full compliance with the court's orders regarding the elimination of any list within the TSDBs that contains individuals who do not meet the known or suspected terrorist standard, and ensure that no illegal human experimentation program such as the Targeted Individuals Program continues or exists in the future. Award damages and attorney's fees and costs pursuant to under 28 U.S.C. Section 2412, 5 U.S.C. Section 552, A, 4, E, I, and Bivens. Grant such other and further relief as the court deems just and proper, such as the imposition of a monitor to ensure defendants take the immediate and long-term measures to ensure that they will abstain from their unconstitutional conduct, and plaintiffs demand trial by jury. Respectfully submitted, A.N.A. Luisa Toledo /S/Ana Luisa Toledo, Southern District of Texas, number 3825092, attorney for plaintiffs, P.O. Box 15990, Houston, Texas 7722015990, Ana Luda at proton.me, dated this 12th day of January 2023.
All right, that was the complete text from the complaint that they filed back in the 11th of January 2023, and I'm exhausted just listening to it. So this is the attorney, Ana Toledo. You can look her up. I believe there's a video here at the website. Where's the video? At the very top. You know what? Here we go. So this is her. You can watch this on the Targeted Justice website and listen to what you have to say. I guess you can be a member of this website, but they're asking for $19.99 or something, $19 a month donation to help them. I would imagine that's being a member. And I'm curious to know the outcome of this case. So on the very bottom, it said the plaintiff, they want a trial with juries. So they want to go to trial. And usually when you go to trial, that's where you make the big money. So let's see if they can actually get the evidence to prove their claims. Very interesting. Well, thank you all for joining me. I got to go now. It's been over 4 hours. Have a good Saturday and no fear. Shum Hong, signing out.